may be listed.
Commercial item number 1.
Briefটা দাও নিয়ে চলে গেল
Mr. Mittal, we have gone through the judgment,
Yes.
both of us in details.
I shall then just
Yes.
make the point that I want to.
Yes. Please, prima facie will indicate, will express our mind. Prima facie, we see nothing wrong. Now you tell us what is wrong.
Well, my first submission will be this, that kindly see this is an application under Order 39, Rule 1 and 2,
Yes.
read with Section 151.
No power.
Yes, whether such kind of an order could have been passed. That's the first point that I am going to make before your Lordship. Kindly, my Lord, come to page 33 of the judgment in the my Lord, memorandum of appeal. This is the order which has been passed. Kindly first come to the order, my Lord, the judgment itself. The page 1, paragraph 1. The instant application has been filed by the plaintiff under Order 39, Rule 1 and 2, read with Section 150 on the Code of Civil Procedure, praying for relief stated therein. My Lord, I shall be very brief, my Lord. I don't want to trouble your Lordship unnecessarily.
Yes.
Then kindly come to page 33, paragraph 46.
Internal page 33.
Internal page 33, paragraph 46 of the judgment.
Yes.
Accordingly, the court appoints Shobhi Ghosh, advocate, and Jayanta Mukherjee, the joint receivers in the instant case, with the following directions. And the directions are, my Lord, the respondents are hereby directed to deposit a sum of rupees 18 lakhs 30,000, and then, my Lord, withdraw a sum of rupees 15 lakhs. They will be entitled to withdraw a sum of 15 lakhs, leaving a balance of rupees 3 lakhs 30. Then, my Lord, the receiver had directed to open a current account. Then petitioner is directed to pay rupees 25,000 per to each of the learned receiver initial fees. The receiver shall have liberty to raise their respective bills. If required, learned receiver may have liberty to approach this court regarding this, etc. Then, my Lord, kindly see on paragraph 48, petitioner is hereby directed to file money receipt by 28/7/2025. If the same is filed, the writ will be issued accordingly. My Lord, so this is the order that has been passed. But my first submission is this: Order 39, Rule 1 and 2 does not permit this kind of an order to be passed. So, my Lord, I am submitting to your Lordship that this order is not justified by the provision under which it has been made. The application is kindly, my Lord, come to Order 39, Rule 1.
That is a question of nomenclature, Mr. Mitro. If otherwise the court has power, mentioning a wrong section is neither here nor there.
But then again, under which provision?
So that is different.
Yes.
If the court does not have the power, it does not have the power.
Well, my submission will be this, that this application having been made under Order 39, Rule 1 and 2, in a suit, pending suit, in which, my Lord, the plaintiff has filed a suit against my client for eviction. Because according to them, I don't have any right to be on the property.
Your claim to be a thika tenant
That has
has
been-
gone.
That is gone. I
Finally
my
gone.
lord, that is gone, my lord, up to the Supreme Court. In the Supreme Court, initially it was held
Correct.
that I am a tika.
But review,
In a review, my lord,
yes,
the judgment has been set aside. This is a very significant thing. But
very rare.
if-
Very rare.
so, my lord, but I cannot therefore urge this point of tika or anything. My lord, the suit that has been filed by my client has also filed a suit. There are two suits pending. One is a suit for eviction by Money Square against my client, saying that I don't have any right, title, and interest in the property. I am a complete trespasser, there I should go. And my client has filed a suit, a sort of counter suit, your lordship can say. Which two suits will have to be heard together?
In this court, your suit is also in this court.
In that court.
I mean, it's in that court. Yes, yes.
In that court, my lord, the two suits are pending. My suit is, my lord, for a declaration that I am the owner, I become the owner of the property.
By adverse possession.
By adverse possession. But I know, my lord, adverse possession plea is not looked upon by your lordships as a very acceptable thing. But then again, my lord, it's a point of law. One has to go in. From 1993, when the lease of my client expired in the property, the owners of the property did not assert their right at all. I did not pay anything at all. From 1993 onwards, I had been staying on that property. For 30 years, I had been there until I filed the suit. So, my lord, they rightly or wrongly, they have, my lord, put up this particular defense, saying that you cannot dislodge me unless you get a decree. And I am going to resist your decree because I am contending that I have become the owner of the property, therefore you have no right. So, my lord, one party is saying you don't have any right, get out, and the other party is saying I have acquired a right, therefore you don't have any right to become the owner of the property. So this is the scenario in which, my lord, this litigation went. Now, my lord, at this stage, my lord, there is no decree either in favor of the plaintiff, in favor of Moniskar, nor is there any decree in my favor. Both suits are pending. Order 39 Rule 1 and 2 applications have been made for the purpose of getting certain money, because I am staying on that property without paying anything. I am not here.
Are you staying or have you let out again?
No, but what happened was this: it was let out. I was earning money, but before the suit was filed, this particular party went. Therefore, I am now sitting on it, and thereafter, this order of injunction has been passed in Order 39, Rule 1 and 2. Result is this: I cannot, my lord, let it out to anybody. I am not earning a single farthing out of this, and I have been directed to pay 18 lakhs of rupees per month, because that was the rent. At one point of time, I was not the rent. That is the income that I was having from that property at that point of time. Now, today, therefore, the situation is this: there is an order of injunction against me, restraining me from letting it out, inducting anybody on the property. And, my lord, I have been directed to pay, my lord, 18 lakhs and odd rupees. Well, this is where, my lord, I am aggrieved. I have come.
Supreme Court also directed you to pay some money, if you remember
Yes,
correctly.
yes, that has been paid. That has been paid, and that has been.
Why did the Supreme Court direct you to pay money?
At that point of time, my lord, this tenant was there. So it was pointed out. It was pointed out that this particular property was earning this amount of money. So the court said that 20 lakhs of which you pay. Very well. Supreme Court has said so at that particular point of time. Today, I am submitting to your lordship that when the property is vacant, I am sitting on that property, not earning any money. This direction on an application on Order 39, Rule 1 and 2, whether it is not. But I am going to be very short in my submission. Well, I just want to draw your lordship's attention to one or two. Well, kindly take this judgment.
Justice Bhaskar Bhattacharjee.
Yes. This is a division bench judgment. And, my lord, in this judgment, Poonam Kejriwal, এটা হচ্ছে 2009 Calcutta High Court notes, page 1, copy দেবো AR 2009 Calcutta, page 250.
So the 2009 PCH and 194.
Poonam Kejriwal was the one. হ্যাঁ কপি কপি দিয়ে দাও। My lord, kindly come to, I am not troubling your lordship with my lord, the submissions made by the parties. Kindly come to page, the page is written somewhere, page 4 at the top. Page 4.
Have you seen the spelling of the name of the second counsel appearing for the appellant? Calls for contempt
Second counsel.
for the appellant.
My lord, it will be contempt now perhaps, but not then. My lord, kindly come to page 4. My lord, before that, sorry. Kindly come to the page 2. Page 2. Well, paragraphs are not marked. Page 2, about the middle of it. Page 2, middle. The case made out by the plaintiff. Your lordship has got.
Yes.
The case made out by the plaintiff was that there was an agreement for license between the plaintiff and the defendant number 1 for 11 months, but even after the expiry of such license, the defendant number 3, the wife of the defendant number 2, had been staying in the suit property. According to the plaintiff, the defendant number 3, the wife of the director of defendant number 1, is a rank trespasser and has no right to stay in the said flat. Now, my lord, kindly come to, then, my lord, in this connection suit, an application under Order 39, Rule 1 and 2 of the Code of Civil Procedure has been filed. And, my lord, kindly come to prayer. There are various prayers here. And, my lord, one of the prayers is the prayer F on the next page. An order of injunction be passed, directing the respondents and each of them, jointly or severally, be to make deposit in such manner as this learned court may deem fit and proper, the mean profits at the rate of rupees 10,000 per day. Then said application was opposed, etc. Now, my lord, kindly come to page 4. Page 4, second paragraph. Therefore, the only question that falls for determination in this appeal is whether in a suit for eviction, even of a trespasser, kindly note this word, even of a trespasser, a court at the instance of the plaintiff can compel the defendant by way of interim order, granting mandatory injunction to pay or deposit certain amount as occupation charge. This is absolutely on the point. Then before answering the aforesaid question, we should bear in mind that the plaintiff has preferred this first miscellaneous appeal against an order of rejection, etc. I am not troubling your lordship. Then Order 39, Rule 1, Rule 2 have been quoted. On the next page, then, my lord, page 5. In the case before us, the paragraph just after quoting, my lord, Order 39, Rule
Yes.
2. In the case before us, the plaintiff has described the defense number 3 as a trespasser and has prayed for recovery of possession and also for mean profits as a final relief in the suit. In the application for temporary injunction, although the plaintiff prayed for injunction restraining the defendant from entering into the suit property, such prayer was not made before us, and the learned counsel for the appellant pressed for passing the order for direction upon the defendant number 3 to deposit occupation charge in mandatory form as an interim measure. The law relating to the grant of interim mandatory injunction is now well settled by the Supreme Court. 1990 Supreme Court, my lord, C.D. George's case has been quoted. Then, my lord, subsequent Supreme Court, the last paragraph on that page, Supreme Court 2004-7 Supreme Court cases have been quoted. And, my lord, from there, the quotation is there on the next page. Once the possession of the appellant, either directly or through his agent, caretaker, is admitted, then the fact that the appellant is not using the said property for commercial purpose or not using the same for any beneficial purpose, or the appellant has to pay a huge amount by way of damage in the event of his losing the case, or the fact that the litigation between the parties is a luxury litigation, are all facts which are irrelevant for changing the status quo in regard to possession during the pendency of the suit. Then, my lord, the court says, therefore, the mere fact that in the event the suit succeeds in the long run, the defendant number 3 would be required to pay huge amount of mean profits is no ground to pass a mandatory injunction disturbing possession of the defendant during the pendency of the suit. If that be the position, there is also no ground for passing a direction upon the defendant by way of mandatory injunction to deposit any amount of money as occupation charge as condition for a stay by way of security, because there cannot be a mandatory injunction for payment of money by temporary measure even before passing of the decree for mean profits, the injury being not irreparable and being capable of being compensated in terms of money. Therefore, in the facts of the present case, there is no scope for grant of temporary mandatory injunction within the ambit of Order 39, Rule 1 and 2. Then, my lord, Purushottam Das Bangur has been dealt with. Then, my lord, it has been quoted. My lord, kindly come to the next page. My lord, it has been quoted. The submissions of the learned counsel in that matter has been quoted in paragraph 7, which has been quoted here at page 7. Then, my lord, it appears from the decision after the, my lord, italics. It appears from the decision. Their lordships did not consider the case of Metro Marine because, according to their lordship, the court was not granting any order of injunction against the respondent except passing a direction for deposit of rupees 25,000. In other words, according to the said decision, passing of directions for deposit of a fixed amount of money every month is not an order of injunction. If that direction is not an order of injunction, in our opinion, refusal to pass such direction by the learned trial court in this case cannot bring the case within Order 43, Rule 1R of the Code to make the order impugned an appealable one. Secondly, it appears from the decision in the case of Purushottam Das Bangur that in that case, no proposition of law was laid down as to whether the suit for eviction of a tenant, if the tenant encroaches the property of the landlord, which is not the subject matter of tenancy, a court dealing with such suit can, in addition to any amount equivalent to the rent last paid by the tenant in terms of the West Bengal Premises Tenancy Act, can direct the tenant to deposit such other amount for occupation, which according to the landlord is not even the subject matter of the tenancy. Their lordship simply passed the direction by keeping the points open. It is now settled law that a decision is only an authority for what it actually decides. Then, well, next paragraph, it is therefore apparent that in the case of Purushottam Das Bangur, the apex court, for doing complete justice between the parties in exercise of its power, conferred under Article 142 of the Constitution of India, passed such direction. This is very important. So, Supreme Court passing the order directing me to pay deposit 20 lakhs of rupees and monthly 1,50,000 or whatever it is for a time, that is, my lord, in exercise of the power under Article 142 of the Constitution, which power, my lord, the High Court doesn't have. Then, my lord, the next paragraph is very important. We therefore hold that in a suit for eviction and mean profits against an alleged trespasser, there is no scope of passing any interim order in terms of Order 39 rule or Order 39 of the Code to direct the defendant to pay any amount of money as occupation charge as condition of staying in the property before decision on merit. The learned judge thus rightly dismissed the application under so and so order. So, my lord, I am relying upon this. না ঠিক আছে, ছেড়ে দাও, সুপ্রিম কোর্ট পাস করতে পারে, সুপ্রিম কোর্টের নানা রকম পাওয়ার আছে। আর 142 তে দেখতেই পাচ্ছ এখন সুপ্রিম কোর্ট কি অর্ডার পাস করছে, castigating somebody else's some other court's judges. So, well, I'm not going into that. Well, this is one judgment that this is one my lord, provision of law that I'm going to rely upon to, my lord, assail this particular order. My lord, the second point is this, my lord. The suits are pending. Maybe what I contend may not be the correct position. Maybe, my lord, ultimately I will be evicted. a decree for possession will be passed. Maybe, my lord, my suit may not succeed and may be dismissed. I am looking the conversely. It is possible that I will be able to establish my case when the suit comes up for hearing. My lord, in respect of adverse possession, if I can show that from 1993 up to 2023, when this suit was filed, for 30 years, I was in possession of the property without paying a single farthing, and nobody challenged my position. Therefore, in other words, my position was adverse to that of the landlord. Then, my lord, in terms of the law of the land, I established my title. My lord, in a situation like this, when there is no decree for eviction, when there is no finding of the court that I am a trespasser, my lord, I respectfully submit to your lordship, no order for, my lord, deposit of the money could be passed. This is the second point I am making, because, my lord, the learned judge, trial judge, has, my lord, almost proceeded on the basis that I am a trespasser, therefore I am liable to be evicted. On the basis of that, my lord, this impugned order has been passed.
Isn't there some observation or finding of some division bench in this proceeding that your client actually has no right? That is referred to in the impugned order.
My lord,
So at this stage, we'll have to take a prima facie view.
my lord, I have been instructed, my lord, and this
Yes.
is subject to correction by my learned friend, that the observation your lordship is thinking of
Yes.
was made, my lord, when the disputes were going on between, my lord, with my client on the basis of tika tendency.
Anyway,
And,
we'll have to
just-
consider that, whatever
Yes.
the
And,
observation.
my lord, that judgment of Justice Jyotirmoy Bhattacharya, with the observation which was made, my lord, that was set aside by the Supreme Court.
Oh, I see.
And then again, my lord, the Supreme Yes. In review, my lord, that was reinstated.
When the final disposal was of it.
Yes, that's right. I said that it was, that's why it
So
was.
kindly show us whatever the
Yes.
finding is, we'll have to consider that.
Yes. Well, therefore, this is one aspect of the matter. Second aspect of the matter is this, that the court directs, my lord, this kind of occupation charge or mean profits to be paid when, my lord, there is the relationship between the landlord and the tenant, or, my lord, the owner of the property and the occupant, has been declared to be illegal, either by way of a decree of a court, or even, my lord, by an overt act on the part of the landlord. Now, in the facts of the instant case, this particular issue with regard to adjudication is pending. So, my lord, in a situation like this, my submission will be on the basis of the various judgments, including, my lord, that of Supreme Court, that so long as the tenant of the occupant's position has not been declared to be illegal, and, my lord, a decree for eviction has been passed, so long as that doesn't happen, my lord, the direction for occupation charges cannot be given. My lord, on that issue, on that aspect of the matter, my lord, I will request your lordship, my lord, to look a few of the judgments. My lord, I will submit to your lordship that kindly, my lord, take one judgment reported in 2024 fourth Supreme Court cases. আমাকে গুলো দাও, আমাকে where are the judgments of Param? Where is that? That we have none. দাও আমাকে. The learned judges must have. No. আগে first দাও এটা. Ashmal. This is reported in 2024 fourth Supreme Court cases 696. আমি একটা কপি দেব। 2024 fourth Supreme Court cases 696. But you will kindly give me 1 second. Okay. Then 5-1 Supreme Court cases, page 705, Akbaram's case. I shall come back to this one.
Come back.
Lordship, will you please to take, my lord, the paragraph on which I want to rely upon.
Atmaram. এটা তো হ্যাঁ market rate rate মানে
Kindly come to paragraph 16.
correct. রাখো।
Paragraph 16. We are therefore of the opinion that the tenant, having suffered a decree or order for eviction, may continue his fight before the superior forum, but on the termination of the proceedings and the decree or order of eviction first passed having been maintained, the tenancy would stand terminated with effect from the date of the decree passed by lower forum. In the case of premises governed under the rent control legislation, the decree or eviction on being affirmed would be determinative of the date of termination of tenancy, and the decree affirmation passed by the superior forum at any subsequent stage would not, by reference to the doctrine of merger, have any postponement. Then, my lord, kindly come back to well, I can't find the paragraph. I want to the paragraph until the possession becomes illegal. Your lordship will please to come to well, kindly come to paragraph 11 if the, of this para. তারপর বার করে দাও, এগুলো তোমরা না দেখে করে দাও। আমার এগুলো আসেনি আমার kindly come to paragraph 11. Under the general law and in cases where the tenancy is governed only by the provisions of the Transfer of Property Act, once the tenancy comes to an end by determination of lease under section 111 of the Transfer of Property Act, the right of the tenant to continue in possession of the premises comes to an end, and for any period thereafter for which he continues to occupy the premises, he becomes liable to pay damages for use and occupation at the rate at which the landlord could have let out the premises on being vacated by the tenant. In the case of Chandrakali Bai, the tenancy of premises were situated in the state of Madhya Pradesh, and the provisions of MP Accommodation Control Act 1961 applied. The suit for eviction was filed on 18/3/1973 after serving a notice on the tenant terminating the contractual tenancy with effect from 31/12/1972. The suit came to be dismissed by the trial court, but decreed in the first appeal decided on 11/8/75. One of the submissions made in this court on behalf of the appellant tenant was that no damage from the date of termination of the contractual tenancy could be awarded. The damages could be awarded only from the date an eviction decree was passed. This court took consideration of the definition of a tenant as contained in Section 2I of the MP Act, which included any person continuing in possession after termination of his tenancy, but did not include any person against whom an order or decree for eviction has been made. The court, persuaded by the said definition, held that a person continuing in possession of the accommodation even after termination of his contractual tenancy is a tenant with the meaning of MP Act, and on such termination his possession does not become wrongful until and unless a decree for eviction is passed. However, the court specifically ruled that the tenant continuing in possession even after passing of the decree became wrongful occupant of the accommodation. In conclusion, the court held. Therefore, my lord, my submission is this, that until there is an adjudication that this person is in wrongful occupation, my lord, his occupation does not become wrongful. Whether it is in case of a tenant or even in case of a person who is holding the occupation by way of, my lord, adverse possession. My lord, this particular judgment had been followed in various subsequent judgments. My lord, kindly give me once again. 60, I mean, 21. Lordship will please to come to another paragraph, paras. Well, kindly come to para 18 of this judgment, Akparam. That apart, it is to be noted that the appellate court, while exercising jurisdiction under Order 41, Rule 5, that is stay of the decree of the court, did have power to put the appellant tenant on terms. The tenant, having suffered an order for eviction, must comply and vacate the premises. His right of appeal is statutory, but his prayer for grant of stay is dealt with in exercise of an equitable discretionary jurisdiction of the appellate court. While ordering stay, the appellate court has to be alive to the fact that it is depriving a successful landlord of the fruits of the decree and is postponing the execution of the order for eviction. There is every justification for the appellate court to put the appellant a tenant on terms and direct the appellant to compensate the landlord by payment of rent. In Marshall and Sons, this court has held that once a decree for possession has been passed, the execution is delayed, depriving the judgment creditor of the fruits of the decree. It is necessary the court to pass the appropriate order so that the mean profits may be equivalent to market rent, etc. So, my lord, this judgment is clearly on this point, that only because the possession of the tenant has been determined by a notice, but no decree for possession has been passed, then, my lord, that does not entitle, my lord, the landlord to ask for mean profit. There has to be a decree, and, my lord, once the decree has been passed, then the landlord should not be deprived of the fruits of the decree. And that is why Order 41, Rule 5 comes into operation. This is a statutory right. The claim for mean profit comes into operation.
In all these cases, there initially was a contractual tenancy, wasn't there?
Yes. There was initially there was a contractual tenancy. All these judgments, my lord, excepting the judgment of Mr. Justice Bhattacharya, there it was a case of trespasser. Allegation was trespasser. There, my lord, Order 39, Rule 1 and
here, what is their allegation? You're a trespasser.
Yes.
In the plaint.
Yes, my lord, they have purchased this property. 1993, there was a lease in my client's favor. That lease, my lord, expired sometimes in,
So 1973.
sorry, 1973, my lord, the lease was given, and in 1993, it expired. And from 30th November 1993, after, my lord, the lease expired, the landlords, for some curious reason,
The lessees were the Kumars, no,
yes,
Kumars.
lessees were the Kumars.
You are claiming under the Kumars.
Well, I am Kumar.
You are Kumar.
Yes. They have filed the suit. The lessors were Ghoshes, they owned the property. They sold the property to Money Square. After Money Square became the owner, the Money Square became, my lord, very active in the matter of getting rid of me. Very well, they are entitled to do so. So they filed the suit. Well, initially, it was registered on the ground of Tika tenancy. I said that I will not vacate the premises because I am a Tika tenant. Supreme Court directed, the final decision of the Supreme Court on review was that I am not a Tika tenant. Therefore, my lord, their contention, therefore, in the suit is the suit was filed thereafter. After the suit.
And in these proceedings, only Lakshmi Mani Dashi was affirmed.
Yes,
by the
yes.
Supreme
That
Court.
was
Yes.
Lakshmi Mani Dashi had been affirmed in earlier decisions also. Here, my lord, again, my lord, reaffirmed. And my lord, if we proceed on the basis of, my lord, adverse possession, in 2005, if your lordship calculates,
Yes.
my lord, in 1993, my lord, from 1993, I am claiming to be in adverse possession. This 12 years expired in 2005. So in 12 years had expired. So at the end of 2005, I'm saying I become the.
Sorry, Mr. Mitru. Did they file was there an earlier suit for your eviction?
No, no. This is the first suit. And my lord, after 2000, they filed a suit in 2007. So what I am claiming is that by the time you filed a suit for my eviction, I, by reason of the law of prescription, I have become the owner of the property.
Before that, there was no demand,
No,
nothing.
nothing. That is why, my lord, they have come up before your lordship. Or I submit to your lordship today this, that
There is no way you can settle this matter through mediation.
my lord,
We are going through a 90-day mediation drive, national drive.
my lord, Money Square will not settle. Whatever, my lord, my intentions are, our client's intentions are, your lordship will ask them.
Any possibility, Mr. Kaur? Mediation?
Get possession.
If you get first possession.
কি বললে? না না শুনলাম না কি বললে?
If they get possession.
কি বললি?
Starting from 2003, we are in 2025. Lord, we have fought it out. Lord, throughout. Before the Thika controller, we lost. Before the land reforms tribunal, we lost. We succeeded before the division bench. Then Lord, a round in the Supreme Court where we lost. Then Lord, review, we succeeded. Then Lord, finally the matter was heard and disposed of in our favor. So Lord, from 2003, this journey started. Lord, 2025, Lord, is perhaps a little late, Lord.
All right, yes.
No, not 2025. 2023, you filed the suit.
Yes, I filed the suit in 2023 because
So I'm giving you 2 years latitude.
right to sue was restored in 2022 July.
By the Supreme Court.
By the Supreme Court. Because property waste, Lord, in the Thika control. So therefore, Lord, I was trying to resist that wasting. And I am the one who, Lord, fought up to Supreme Court.
No, that is all very well. My answer to that is this, that you have succeeded in the Supreme Court by disputing that I am a Thika tenant. To that extent, you have succeeded. But I am still on the property. And I am saying that I have been in the property since 1973. 1993 lease expired. From 1993 onwards, I have been staying.
Mr. Mitru, theoretically, you may succeed, your suit may succeed, or their suit may succeed.
Correct.
Both can't succeed together. Now, at this stage, we'll have to take a prima facie view
Lordship.
how far you are likely to succeed, and then put you on terms, maybe, we don't know, as the learned judge has done, taking a cue from the Supreme Court's order also, maybe under 142, maybe not, it's not that. But the whole idea of being in possession
Without paying any
without
money.
paying is not very happily taken by the courts.
And I quite appreciate it. I quite.
Page 77. Payment of occupation charges because in the application page 46, this is a page 77.
Page 46 is all right, but at that time the contention was that it's a tika tendency. That in the dispute with regard to tika tendency. Very well. My lord, your lordship will please to come to page 77. Page 77, my lord, kindly see. Volume 1. If your lordship, my lord, takes volume 1, page 77.
Application का लिखिए दो
My lord, kindly see, come to page, this application on which, my lord, this application was made. This is an application for direction at page 46. My lord, application of money square, application for directions before the Supreme Court. Here, my lord, kindly see the prayer at page 73.
73 of the stay petition.
Of the volume 1. In the stay petition, page 46. There are 2 volumes.
Order 39 application.
No, my lord. This is a miscellaneous application in the pending appeal, which was before the Supreme Court. My lord,
Oh, Supreme Court. Sorry.
yes. This is before the Supreme Court. Your lordship will please to see that in the so far as Supreme Court is concerned, the Supreme Court in review application, the order which was passed is, my lord, on 2022. 2022, if your lordship, my lord, and then, my lord, this application was made on 9th November 2022. And the application was that in view of all that, directing the appellant to forthwith hand over and deliver vacant and peaceful possession of the said premises to these respondents. Then B, directing the appellants to pay to these respondents occupancy charges of an amount of rupees 1,07,07,885 as computed in paragraph 15 above, along with interest from the date of payment of each installment of the occupancy charges till realization. Directing the appellants to pay an amount of rupees 8 crores 96 lakhs 80,976 to this respondent toward the illegal rent received by the appellants by illegally letting out the said premises. And, my lord, on that, an order was passed, which is, my lord, at page 77. Having heard the page 77, this is the order dated 12th December 2022. Having heard the learned senior counsel for the parties and having perused the material placed on record, we find no reason to entertain the application for any relief prayed therein. The application stands rejected. Needless to reiterate that the applicant is otherwise free to take recourse to appropriate remedies in accordance with law. My lord, then they filed the suit. So, my lord, this prayer was made before the Supreme Court also at the time, and this order was made, as I have shown to your lordship, on 12th December 2022. and the suit was filed by the
So
respondent.
this application was made and the order was passed after they succeeded in the review,
Yes, yes.
Main matter, after disposal of the main matter.
main matter.
And my lord, this is up the Supreme Court order was 27 July 2022. And there, my lord, on review, 27 July 2022 is the order of the Supreme Court,
Where
final
is
order.
that? Where is that?
My lord, that is at page.
That is culminated.
না কিন্তু এটা এখানে অর্ডারটা রয়েছে my lord, this order I have got a copy of the judgment by which, my lord, this particular order was passed. This is, my lord,
It's not on record. They have not annexed it.
this is 2022 SCC online Supreme Court page 920. This is ও দিয়ে দিয়েছে। My lord, kindly come to paragraph 126. After this long judgment paragraph, there are 125 paragraphs discussing, my lord, various aspects of the matter. Then conclusion is in para 26, 126. In summation of what has been discussed here and above, we could broadly say the full bench decision of Calcutta High Court in Lakshmi Rani Das is affirmed. That's the first one. The structure as put by the appellants and or their predecessor had been Pakka structure. That was the reason why, my lord, it is a reversal. For the structure being Pakka in character and the terms of the lease being 20 years, the appellants and of their predecessors were not tika tenant within the meaning of section 2, subsection 5 of the Act of 1949. Then 4, the appellants and of their predecessors were not tika tenants with the meaning of the Act of 1981 for two major reasons. A, the structure in question was a Pakka structure for, my lord, possession before the Supreme Court, which I just now showed to your lordship.
After this order,
After this order, and they, my lord, asked for, my lord, mean profit.
Supreme Court said take steps in accordance with
Yes.
law. Yes.
So the
No, just one thing, Mr.
yes,
Mitro.
yes,
Para 127,
120,
just now you placed para 127
126.
and 7. This orders dated 15th April 2014 and 22nd July 2014 directing you to make payments towards occupancy charges. These were orders passed by
But the Supreme Court,
Supreme.
in the pending tika application, before the review came up, the review was a subsequent event, my lord. After the Supreme Court had come to the conclusion that I am a tika tenant, my lord, they kept quiet. My lord, the review application was made. Review application, the Supreme Court reversed its judgment, my lord, which was delivered earlier.
Can we have a look at this division bench judgment which was affirmed by the Supreme Court?
My lord, that ওটা আছে তোমাদের কাছে? ওটা নেই। তোমার কাছে আছে ডিভিশন বেঞ্চ তোমাদের কাছে জজ সাহেবের দাও, জজ সাহেব চাইছে। But I don't have a copy of that. Extra copy থাকলে হবে। যদি থাকে। Thank you.
Supreme Court judgment. The relevant portion is quoted from para 60 of the Supreme Court judgment, your lordship's mind. That paragraph 41 and 42 has been quoted.
41 of the High Court judgment. Division bench paragraph mark করো না একটু। হ্যাঁ, আমাদের অন্তত এই জাজমেন্ট এটা কিভাবে আরম্ভ হচ্ছে বলতো? একদম ঠিক আছে। Hey, 41.
This is what the division bench observed, Mr. Mitra, as quoted by the Supreme Court
Got it.
also. After expiry of the said lease, the lessees became trespassers, and or at best they may be regarded as tenant by sufferance.
Yes. But this is no finding on my status. This is with vis-a-vis, my lord, the issue with regard to, my lord, tenancy, this observation was made. I mean, at that stage, my lord, the court did not have the occasion to decide
Yes, correct.
as to my say,
Correct.
accepting whether tika tenant and or not.
Correct.
In that context, my lord, this observation was made.
Yes.
So, my second point, as I indicated to your lordship, is this, that so long as my status is not determined, whether the court should pass any order with regard to mean profits or occupation charge. Well, these judgments, my lord, which are quite a few in number, well, these judgments have gone on to say that until, my lord, it is decided with regard to, my lord, I can give your lordship, my lord, the references of this. Judgment. Yes. My lord, Supreme Court judgments, my lord, I tell you, lordship, kindly give me 1 second. My lord, the judgments of, my lord, kindly come to one judgment 2005 Supreme Court case আছে। এই দুটো জাজমেন্ট দেখো না বার করো 2005 and 2022-8 না আসমান ওটা না এটা হচ্ছে হ্যাঁ 5-5 অচল মিশ্র দাও জজ সাহেবকে my lord I was relying upon this, my lord, kindly take, my lord, 2005 Supreme Court cases 531 Achal Mishra's judgment, copy দাও 2005 Supreme Court cases 531 দাও না আমাকে বসো আর এটা বার করে রাখো my lord, kindly come to para 23 at 542 and Atmaram Properties Federal Motors have been referred to here. Para 23. From the materials available on record, it does not appear that any rate of rent was appointed, at which rent would be payable by the respondent to the landlord. The respondents also do not seem to have taken any steps for fixation of rent of the premises in occupation. They have been happy to have got the premises in a prime locality, occupying and enjoying the same for no payment. We make it clear that the respondent shall be liable to pay the rent equivalent to mean profits with effect from the date with which they are found to have ceased to be entitled to retain possession of the premises as tenant. And for such period, the landlord's entitlement cannot be held pegged to the standard rent. Reference may be made to the. So, therefore, my lord, here again it says that, my lord, they will be, my lord, found to have ceased to be entitled to retain possession. From that day onwards, they will be entitled to, my lord, the occupation charge. My lord, here, if your lordship, my lord, comes back to this judgment, my lord, considered various earlier judgments. And, my lord, after considering this, this is what they held. I am relying upon this only for this, well, short proposition that they will be they will be liable to pay the rent equivalent to mean profits with effect from the date which they are found to have ceased to be entitled to retain
Yes,
possession.
Mr. Mitro, the problem is for your client,
Yes.
as we see at the moment, there is rightly or wrongly a finding of a division bench of this court, upheld by the Supreme Court, that your client is a trespasser. There is no finding as of date that your client has acquired title or has become owner by adverse possession.
Well, I have filed a suit for that. That
Yes,
is,
yes.
well,
Now, what we are
definitely-
saying, as
yes.
of date, there is no such order in your favor.
No, no.
But there is an order on record saying your client is a trespasser.
Yes.
We'll
That
have
has
to
been- that-
balance the equities. That's all.
Yeah, Lord, I quite appreciate what is falling from you, Lordship, but yes, I mean, it goes against so common sense that a person who is in the occupational property, why should he stay there without payment of inmate?
And against whom there is a declaration or observation of a
No,
division
observation,
bench.
not a declaration. This is an observation.
Observation that he is a trespasser.
My lord, the trespasser vis-a-vis, my lord, whether he was a tika tenant or not. If I am a trespasser, I am proceeding on the basis I am a trespasser. What I am saying is that, therefore, I am going to take advantage of that observation. The court has said that I don't have any tenancy right. I don't have any right in the property. I am holding on to the property as a trespasser. I am showing to your lordship that as a trespasser, I am there for more than 12 years. I filed a suit for a declaration. So, my lord, why can I not, my lord, take advantage of that finding?
When are they fighting litigation with? From when? Litigation with you?
My lord, after, my lord, Money Square came into the picture. Money Square purchased the property sometimes when? 2007. Then, my lord, they wanted to have the possession of the property. The question of tika tenancy was raised. That was, my lord, I succeeded, my lord, in the first 2 rounds. Then, my lord, I lost. Then, my lord, matter went to the Supreme Court. I succeeded in Supreme Court. And thereafter, my lord, I lost again in the Supreme Court by way of review. So it has got a checkered career. And in this context, my lord, the learned judge, the division bench was pleased to hold that a trespasser. I am proceeding on the basis that I am a trespasser. I am not claiming in a tenancy right.
এই আগের দিনের অর্ডারটা দেখি একবার আগের দিনে কোনো অর্ডার আছে না কোনো অর্ডারটা
এর আগের দিন অর্ডারটা কোথায়?
But we are hearing out the appeal, let us understand.
If your lordship
What remains? I mean, we have heard you at length, we'll hear them.
oh yes, very well. Well,
In-
there is one other. These are the points, my lord, I have told
Yes.
your lordship. The only other judgment that I would request your lordship to look into
Yes.
is a division bench judgment, my lord, presided over by, my lord, the learned judge, who has declared, who has made observation that I am a trespasser. Okay. My lord, this is the judgment of this division bench of our court, my lord, in K.K. Shaha versus Ashok Agarwal. Reported in 2018, 1 Calcutta High Court Notes, page 497. And 2017 SCC Online, Calcutta 2123. My lord, will kindly come straight away to para 11. My lord, before that, para 2. The tenancy of the said defendant was terminated by the plaintiff petitioner by issuing a notice dated 29 July 2015 under section 106 of the Transfer of Property Act. Since the defendant did not hand over vacant possession thereof to the plaintiff after expiry of the notice period, the plaintiff filed a suit for eviction of the defendant. In the said suit, he has also prayed for recovery of arrears of rent and also for mean profits till recovery of possession of the suit premises. Several other incidental reliefs have also been claimed by the plaintiff. So I am not troubling your lordship. Now, in this perspective, my lord, kindly come to para 10. Para 11. The learned single judge who was taking up the present revisional application could not agree with the said principles as laid down in Connaught Projects Limited. His lordship was of the view that condition may be imposed by the appeal court at the time of passing of an order of stay of eviction decree or at the time of staying the execution proceedings in an appeal filed by the tenant appellant. But such direction cannot be passed if the eviction proceeding is dismissed by the trial court and the appeal is filed by the dissatisfied landlord. It has also observed by this lordship that on the same analogy, if the suit for eviction is still pending and no decree is passed, it is not open to the court to direct the tenant to pay the occupational charges till the court passes a decree for eviction. So this was the submission made. Then, my lord, para 14. Where the civil court can direct, this should be whether the with this my lord, the reference was sought for on the following point. Since, my lord, there was a difference of opinion between of the trial court, the matter was referred to a division bench for by way of a special bench, special reference, and the reference was whether the civil court can direct the tenant to pay occupational charges, damages, mean profit during the pendency of the eviction proceeding at the provisional market rate in excess of the contractual rent. Then, my lord, said issue has been referred to this bench by the honorable bench. Now, my lord, kindly come to para 22. We will have to examine as to whether an interim direction can be passed by the learned trial court upon the defendant tenant for payment of damages during the pendency of such suit. Payment by way of damages is a payment for wrongful use and occupation of the suit premises. So, for passing a direction for payment of damages by the defendant, the court must first of all decide as to the nature of possession and or occupation of the defendant in the suit premises. Such determination, in our view, depends upon various factors such as existence of relationship of landlord and tenant between the parties in respect to the suit premises, and two, legality of termination of such tenancy in the admitted landlord by service of the notice upon admitted tenant under section 106 of the Transfer of Property Act. And I would add, my lord, the various factors, whether the possession of, I shall add to this, whether the possession of the occupant is claimed to be under the adverse possession. If it is found that there was no dual relationship of landlord and tenant between the parties, the termination of tenancy by notice under section 106 of the Transfer of Property Act will be banned and ineffective. Again, even if the relationship of landlord and tenancy is found to exist between the parties, still then valid termination of such tenancy depends upon the legality and validity and sufficiency of the notice. If it is found that the notice under section 106 of the Transfer of Property Act is invalid and or insufficient and or illegal for any reason whatsoever, the court cannot pass a decree for eviction against the defendant in such suit. Then, my lord, kindly come to para 28. We have already mentioned above that until and unless service of a notice under section 106 of the Transfer of Property Act upon the defendant is held to be good, valid and sufficient, the character of occupation of the defendant in the suit premises cannot be decided, even on prima facie basis in the suit, unless there is admission on the part of the defendant about the existence of relationship of landlord and tenant between the parties and the valid termination of his tenancy by service of notice under section 106 of the Transfer of Property Act in an earlier suit when the tenancy is governed under the Transfer of Property Act. Such being the position, in law, we are unable to agree with the views expressed by the learned single judge of this court in Project's case that even the learned trial judge can issue direction upon the defendant tenant to pay occupational charges at the market rent by way of damages in the absence of any provision in law. Even direction for deposit of damages with any officer of the court is not permissible, as we have already held above that such direction can only be passed after the issue as to the legality of the possession of the defendant in the suit premises is finally decided in the suit. So, my lord, I am relying upon this. I know, my lord, that on a question of equity, it is a very thin thread on which my defense is hanging. But my lord, I am relying upon this for the simple reason that court says this can be only passed after the issue of the legality of possession of the defendant in the suit premises is finally decided. Now, my legality of my existence on the suit property has not been decided at all, excepting for my lord that stray observation of the in the Tika tenancy case. So, my lord, I am submitting to your lordship, relying upon this, that the courts have held that so long as the legality of possession of the defendant has not been decided, my lord, no direction can be passed by way of. My lord, these are basic submissions of mine. I am not going to submit anything else any more than that. There are decisions of the Supreme Court which says that the legality of the possession of the defendant has to be decided at some point of time before, my lord, the order for mean profits can. Mean profit is the damage that you suffer for illegal possession. So whether I am illegal, I am a trespasser. Let me put it this way. I am a trespasser. I am claiming adverse possession. So even if, my lord, the finding of the learned judge of this honorable court is there that I am a trespasser.
It is not the finding of the judge now. It is the finding of the Supreme Court merger.
Very well. Very well, my lord. Supposing it is so. A trespasser is saying I am in possession for more than 12 years without interruption, without being, my lord, my possession is open, and my lord, therefore, there is no reason as to why I should not be and until that issue is decided whether, my lord, any amount can be directed to be paid. But lastly, there's only one other submission I made. My lord, an application under section 12A of the Commercial Courts Act has been made, challenging the maintainability of the suit of my learned friend's client. And, my lord, that's a commercial suit.
Commercial. There was no pre-litigation mediation.
No pre-litigation. And, my lord, there was the delay. There had been 6 months delay without explanation. My lord, kindly take this. Your lordship will please to take, my lord, that section. Yes.
That application is pending.
That application, after disposal of this application, my lord, we insisted, we made
So
an application.
you have asked for revocation of the dispensation.
Yes, yes. And that application was, my lord, pending before the court. So before this application on which this impugned order was passed was taken up, we made a formal application that you take up section 12A application first. And that application has not yet been heard. But the language is very clear.
Mr. Kaur, why wasn't that taken up first? We didn't know about this 12-way revocation.
But let him finish.
Yes,
Because
okay.
12-way, I don't know how many times this 12-way bogey can be raised. It is raised once up to Supreme Court, SLP dismissed. For 2 years, they sat tight, 7-11, 7-10, and then after 2 years, now again that 12-way issue has been raised. And there is a civil revision pending because the learned judge didn't fix that matter. There's a civil revision pending where they sought an interim order. That interim order was refused. The civil revision is still pending as of today.
So it was not.
Mr. Kaur, rightly or wrongly, we don't know. We have not seen. They have applied for revocation of dispensation under 12-way.
They had applied for that revocation in Order 7, Rule 11, and an application. That
Yes,
application found its ending in the Supreme Court. And in the Supreme Court, these grounds were specifically taken. I'll show your lordship the SLP. After dismissal of that Supreme Court SLP, they come and file an application under Order 7, Rule 10. And then, Lord, after dismissal of Order 7, Rule 10, they file this application for revocation. I tell your lordship, Lord, the whole game is, Lord, there is an order passed by the High Court to dispose of the suit within a period of 6 months. In an ALP,
Let him finish that.
Yes,
Let him
that's why I
finish.
said, Lord, I should not interrupt.
Well, my submission is this, that application, then if my learned friend is right in saying what he is saying, that we have there had been our journey on section 12A had been, then my lord, that application could have been taken up, heard, and dismissed. Then I couldn't have said anything. The application is pending, and in fact, my lord, that application has been fixed. Only the last week or so, when we moved an application that this particular learned judge perhaps will not be able to give justice to my client, we moved an application for transfer of the matter. Because my lord, this matter is not being heard. Section 12A, my lord, because it goes to the root. If I succeed in the section 12A application, then my lord, the language is a suit which does not contemplate any urgent relief, and we say that no urgent relief because 6 months, more than 6 months after the Supreme Court had disposed of the my lord, this tika tenancy matter, they filed a suit. For 6 months they were sitting there. So it did not contemplate any urgent relief under the Act, shall not be instituted unless the plaintiff exhausts the remedy. Shall not be instituted. This matter, it goes to the root of the matter. So why should that application not be heard? Dismiss it if you want to. But hear it. So this is the other point that we have taken in this. These are technical points, I know. But here is a person who is frantically trying to hold on to a property on which he had been staying for the last so many years. He is saying that I have got a right. Rightly or wrongly, my lord, he is saying so. So, my lord, that issue has to be decided once and for all. Just by mere in passing a statement saying that it's a trespasser and therefore he is not entitled to stay there, my lord, that is not an adjudication, which, my lord, is can be said to be a judicial adjudication. And if it is not, then, my lord, I respectfully submit to your lordship that this issue has to be decided first before my lord friend can come up by way of this.
Thank you.
And my lord, sorry. কবে চলে গেছে বেস্কো
2022 31st 22
and আমাদের impugned orderটা
20 last 22nd July 2020.
Mr. Kaur, we have fixed a matter at 11:45. Yes, is it Mr. Kundu's matter? Your matter? So we'll hear you tomorrow. Or at দুটোর সময় কি আছে?
At 2 o'clock, I am in little
difficulty. আজকে কি বার? মঙ্গলবার. Tomorrow?
So in the afternoon, Lord, there is no problem. It is in the afternoon. I don't know what time your lordship takes up. Lord.
No, tomorrow is, huh? কবে? আচ্ছা 3:30 কে বলছে? কালকে অন্য কোনো টাইম দেওয়া যাবে? Tomorrow is original side. Otherwise, then Thursday?
Thursday is all right. Thursday is all right.
এই Thursday কিছু ফিক্স টিক্স আছে কিনা দেখো না খাতা। Oh. About an hour for you?
Not more than 1 hour, maximum.
12:15 করা যাবে এটা? হ্যাঁ? Original side দেখে নাও।
On Thursday?
এসো দেখো।
আমি আর করতে পারবো না ভাই, যথেষ্ট হয়েছে।
This appeal is directed against an order dated July 22, 2025, passed by the learned judge, Commercial Court at Alipur, in title suit 04 of 2023, renumbered as TS-com 48 of 2023, filed by the respondent number 1, the respondent herein, filed by the respondent herein for eviction of the appellants from the suit premises and for other reliefs. Stop. We have noted, we have noted in our order dated August 5, 2025, that by the impugned order, the learned trial judge directed the appellants herein to pay occupational charges, pending disposal of the suit. paragraph. We have heard Mr. Joyanto Kumar Mitro, learned senior counsel representing the appellants at some length. Stop. He has concluded his opening submission. Paragraph. To hear Mr. Kaur, learned Joydeep Kaur, learned senior counsel, কি হলো? কি fixed আছে? কি বললাম? Representing the respondent herein, let this matter be listed again on Thursday, date দিয়ে দাও,
14th August.
marked 12:15, which is 12:45 fixed আছে, এটা কার fix করুন? এটাকে এতটা শুনে 12:15 p.m. Is junior in court? Is junior Mr. Banerjee in court?
Don't recognize it.
No, they are growing children. They change fast. So
I said that there has to be a partner to introduce.
I actually smiled at him, and then I thought, if I've got the wrong person, he might think the judge has gone mad. কি করে ঘুরে এসে বুঝলি? দেখে তো আমরা ঘুরে আসি। ও কৌশিক।
the last question. I stopped after.
You're from Digha Shankarpur, Mr. Vitro. Hey.
Map to burger, map to burger. No, no. Report.
Yes, Mr.
Mr. Kundu.
On the last occasion I was on the verge of showing the report filed by the expert. Now, my lord, just to recapitulate, my lord, the expert was wanted by the consent of both the parties, but the expert being a government officer of the state of West Bengal, his name was proposed by Digha Shankarpur authority, and we did not object to that because we did not have the wherewithal or the competence to have a proper expert on these issues, especially with regard to.
And he has said that it is beyond the prohibited zone.
My lord, I would like to show the certain paragraphs from the award, which is at page, my lord.
ইস্যুটা
ইস্যু যেটা যেটা বলছি সেটা মনে না
আচ্ছা এক্সপার্টের রিপোর্ট করতে
রিপোর্টটা বলছি অ্যাওয়ার্ডে
অ্যাওয়ার্ডে কালকে কত
হ্যাঁ।
320 ক্রস এক্সামিনেশন আছে 270
তারপরে
320 হচ্ছে তোমার
320
অ্যাপয়েন্টমেন্ট অফ এক্সপার্ট
your lordship will take up 320. But before that, Bharat, I'll just invite your lordships to go to issue number. Issue number 1 and 2. That is at page, my lord.
312
312. There are two issues which are very important in the present disputes. But at page 312, issues numbers 1 and 2.
Page 312 my lord. This is the paper book my lord, volume 2. After the first paragraph my lord, the two issues are there. First issue was the cancellation of the memorandum of understanding dated 25/11/2004 and the work order dated 29/11/2004 lawful. And the second issue, who was responsible for obtaining clearance from the Pollution Control Board as also the appropriate authority as to the construction of the building on the site in question.
These were the issues. Now, my lord, I'll come back to page 320. That is at the point where the cancellation has been made by the Digha Shankarpur authority of the tender of the appellant. Then, my lord, certain work was already undertaken by my clients. Now, my lord, there was a dispute as to what was the amount of work which was. So for that, one had to only go by way of a survey. So both the parties agreed to a survey of the amount of work which was ultimately made by the my clients till the time they were in possession of the said land. On that matter, both the parties agreed that a sum of 16 lakhs and odd was the amount which was expended by my clients for the work already undertaken, and that was also an issue which was raised by my client by way of an interim award, the learned arbitrator, he awarded a sum of rupees 15 lakhs on the issues which were already on the issue as to whether or not work was done by the petitioner or the claimant, and what was the amount of work which was accepted by both the parties at 15 lakhs.
Yes. সোয়া বারোটায় 12:15 আছে। Yes.
And the Shankar authority did pay the amount.
15 lakhs.
Now, my lord, I'll take your license to page 320 onwards of the award to show two things, my lord. One, as to how the expert had been appointed. Then, my lord, what was the finding of the expert? How the Shankar authority, they did, my lord, cooperate and held the sittings, and the report was prepared in their presence. The lordship will go to page 320, my lord, adjournability. Relevant paragraph.
Lord, may I place from third paragraph, Lord, at page 320. Such issue, my Lord, third paragraph, Lord. Such issue has become further murky in view of the fact that from the report submitted by one Sri Debol Rai, IFS, Member Secretary, West Bengal State Coastal Zone Management and Authority, and Chief Environment Officer, Department of Environment, Government of West Bengal, after physical inspection of such unfinished construction and the area where the same situated at B7 sector of Digha, on the joint prayer of the parties, it appears that the disputed structure in question falls outside the 500-meter CRZ boundary. It is indeed important to note at this stage that after starting of the arbitration proceeding, on several occasions, both the claimant and the respondent were jointly praying that a physical inspection is required to be made, both of the disputed structure as well as the site in presence of both the parties, and this tribunal, and accordingly the arbitration proceeding may be held there. It was also specifically prayed jointly by the parties that such physical inspection of the said structure and the site is necessary inter alia for the purpose of ascertaining the correctness of the measurement and valuation already made, as also to find out whether the disputed area really falls within the prohibited zone, that is within 500 meters of the high tide point under the coastal zone regulation. Since this tribunal had no knowledge or information as to the expert who can be appointed for the aforesaid purpose of bringing out whether the site falls within the prohibited zone of CRZ regulation, the parties were requested to supply the name of such expert, whereupon the respondent themselves suggested the name of Sri Debol Rai, who is also a government officer and expert in the line. Since the claimant was unable to name the expert and clearly submitted that they have no objection at all if such expert as suggested by the respondent is appointed by this tribunal for the aforesaid purpose, in a sitting of the instant proceeding, an order was passed, first of all, fixing two dates, that is September 4 and September 5, 2010, fixing the meeting of the parties and as for such inspection, and also informing the said Sri Debol Rai that at the suggestion of the respondent, he was being appointed by this tribunal as an expert to find out whether the said structure falls within the aforesaid prohibited zone or not, with further direction upon him to make such inspection in the presence of the parties. On the aforesaid two dates, the learned advocates of both parties, as also their clients, were present. First of all, meeting was held in Shoikotabas, where the head clerk and Mr. Mycap for the respondent were present, and thereafter all, including the said expert, proceeded to the site. Admittedly, such inspection was made by the expert Sri Debol Rai and his party in the presence of learned lawyers of the parties and the undersigned. Sri Rai, before making the requisite inspection of measurement for the aforesaid purpose, explained before everybody that the most accurate way to determine the location of the structure vis-a-vis CRZ boundary is to take latitude and longitude of the disputed structure using a high-fidelity GPS receiver and plotting them at georeference map. It was also explained by the said expert that the readings were being taken using a Leica making model NGS20 single frequency GPS, along with different corners of the disputed structure. Thereafter, taking of such measurement before everybody, the said expert mentioned that as per reading, it appears that the disputed structure is outside the prohibited zone. The said expert was directed to submit a report, which he did, with the coastal zone regulation map and the disputed structure at New Digha, along with several photographs of inspection. After submission of such report, although the said expert was appointed at the suggestion of the respondent, and as pointed out herein before, he was a government officer, an objection to such report was filed by Mr. Mycap, affirmed by an affidavit in which the correctness of such report was disputed. In the said objection, it was pleaded inter alia that the said report of the said expert is not true depiction of the actual state of affairs, and according to Mr. Mycap, the disputed structure has been depicted in the Land Use and Development Control Plan, hereafter referred to as LUDCP, and it falls within 500 meter of the coastal zone regulation zone. It was also alleged in the said objection for the first time that the Geological Survey of India has placed post as mark to denote the boundary of 200 meter and 500 meter from coastal zone regulation zone, and the disputed structure falls squarely within the region of 500 meter of the coastal regulation zone. According to Mr. Mycap, the same will be clear from the extract of LUDCP map, which was annexed to the said objection as Annexure X. This tribunal, after considering the said report of the expert, as also other materials on record, as also evidence adduced by the parties, is of the view that the respondent has miserably failed to satisfy this tribunal that the said report of the expert is erroneous. At the 19th sitting of this proceeding held on 18/11/2010, the said Mr. Mycap, in his examination in chief, stated that Annexure X annexed to their said objection indicates that according to them, the disputed structure falls within the prohibited zone. It was further deposed in examination in chief that the said CRZ map in such an annexure was prepared by Geological Survey of India in the year 1995. But admittedly, the original of such alleged Geological Survey map was never produced. He deposed that it was not in his office. Although in such deposition he said that Annexure X to the objection is the photocopy of the original map prepared by GSI. In cross-examination, he clearly admitted that Annexure X is not the exact photocopy of the part of the drawing submitted on the said date, which has been prepared by GSI, and he further admitted that the said Annexure X was not prepared by GSI, but by the Urban Development Department. He further admitted that it is not the extract of a particular MOSA which might have been prepared by GSI. From his cross-examination, it also appears that Mr. Mycap, who has filed such objection by affirming an affidavit, has no knowledge or information about the subject in question. He is not at all aware as to the aforesaid method of measurement by the instrument used in respect thereof, and further admitted that during such measurement and inspection at the site, although he was present, he never raised any such objection. From his cross-examination, therefore, it was absolutely clear that Mr. Mycap had no knowledge, far less the expertise, to dispute the correctness of the said report or of the methodology or measurement for the purpose of finding out whether the particular area falls within the said prohibited zone, and he files his objection only because, according to him, that was contrary to measurement allegedly made by GSI earlier and the pillars posted by GSI for the aforesaid purpose. It is also significant to record that although before going to the site for such inspection and measurement, etc., the purpose of such inspection was clearly recorded in the minutes of the meeting held at Shoikotabas, Digha, during the process of such measurement made by the expert, Mr. Deval Rai, and when he was explaining the method which he was using for making such inspection and measurement, the same was not objected to at all by Mr. Mycap, although he was present representing the respondent. What is more, at no stage of hearing, either at the meeting or at the site or after coming back to the meeting, when the meeting of the parties were held, further he ever pointed out that as per the map drawn by GSI, the disputed structure does not fall within the said coastal zone regulation, or there are markers made by GSI indicating such prohibited zone. At the time of inspection, also, not only did he raise such points, he never also pointed out to the parties as to the tribunal indicating the alleged markers posted by GSI. It is also to be placed on record that at no stage any officer from GSI or record of the GSI indicating the disputed structure and the site having fallen within the prohibited zone or record in respect thereof were produced before this tribunal. Under such situation, this tribunal, in absence of any contrary evidence or materials to such finding of the expert, who is a government officer, has no reason to distrust or reject such report of the expert, but to accept the same. Then kindly, my lord, turns over.
Please the entire award.
Lordship,
You'll please the entire award.
No. We'll just,
this is only the portion of the award.
what is the huge one? This is 27.
Mhm, 24, 25. এখানে একটু পড়ে দিই।
হ্যাঁ, yes.
My lord, page 24, my lord, I was just placing, my lord, two paragraphs from page 24 onwards, my lord. Third paragraph from page 24 onwards.
Yes.
Or rather, I will place from the first paragraph only, my lord, page 324. That apart, the respondents have also miserably failed to show by producing records the decision of the respondent DSDA to the effect that they have no option but to cancel the MOU and the work order as the site in question, which had been handed over by them to the claimant for construction of such market complex, was within such prohibited zone, that is within 500 meters from the high tide point under coastal regulation zone. As pointed out here in above, after awarding of the contract and issue of the work order admittedly by letter dated 24th March 2005, the respondents were asked to suspend the work on the ground some discrepancies relating to the selection of the builder contractor came to notice. Moreover, it was found that proper permissions were not obtained from the Ministry of Environment, Government of India, and the West Bengal Pollution Control Board as required under the rules. But no record has been produced before this tribunal in spite of repeated directions as to the relevant resolution taken by the respondent authority for giving direction to the claimant for suspension of their work on the aforesaid ground. It is also to be placed on record that the documents which have been produced ultimately by the respondent in support of their case merely indicate certain internal correspondences between DSDA and the state government relating to suspension and cancellation of such work, wherefrom also it does not appear on what grounds such statutory authority, being the respondent, after awarding the contract and issuing the work order, had to cancel the same on any valid legal ground. The respondents have produced.
He had it save for the day.
Well, the last paragraph. The respondents have produced at the fact end of the hearing a meeting book of DSDA and exhibited before this tribunal a few pages thereof. One of the same is the proceeding of the meeting of the respondent authority is dated 20th April 2005. From clause 2 of the aforesaid minutes of the meeting, it appears that a resolution was taken for issuing a fresh tender through advertisement for construction of stall, etc. And it was further resolved that MOU signed by the private contractor be cancelled and work order to the contractor be withdrawn, cancelled. It was further resolved that construction of stall at the site be stopped immediately till fresh orders are issued through completion of appropriate formalities and taking due care of CRZ norms and other paraphernalia. It is not clear, however, that whether the same at all relates to construction in question of the concerned site. Another proceedings of the meeting dated 10th May 2005 had also been exhibited. Clause B whereof records that the construction of B7 sector, that is the impugned sector, has been stopped, but the claimant had given the letter expressing their grievance. The aforesaid clause B of the said minutes, instead of supporting the case of the respondent in view of this tribunal, actually strengthened the claims of the claimant. As in the said clause B, it has been stated that on receiving of the letter of grievance expressed by the claimant, the authority, after discussing, resolved that fresh EOI be floated. It may be noted admittedly, in fact, pursuant to such decision, a fresh tender was invited for the self-same area for the construction of the market complex, a copy of which has been annexed at page 54 of the statement of claim. It is not disputed that pursuant to the same, the claimant once again applied for such tender, but such tender was ultimately withdrawn. It is also to be placed on record that although repeatedly this tribunal wanted to know from the respondent if really the MOU entered into with the claimant in respect of construction of such stalls at B7 sector had to be cancelled on the ground that the same lies within the prohibited zone of the coastal zone regulation, how the same authority could float fresh tender for the self-same site no explanation could be given by Mr. Mycap during his cross-examination when confronted with such question by this tribunal and was asked to explain the same. He could not give any answer or any explanation despite the fact a specific issue was framed in respect thereof, namely issue number 4. এবার 329
And one more paragraph, and I'm through with the.
and well, then page 329, the first paragraph. It 329, my lord. It is also necessary to record in this connection that after closure of the evidence and argument by the parties, the respondents in their written notes of argument attempted to introduce totally a new case as a justification for cancellation of the contract. In paragraph 4,
Yes.
in paragraph 4 of the said note, it was alleged inter alia that after the claimant started the construction work, the local residents objected to the same on the ground that the land belonged to Development and Planning Department, and on reference of the same to such department and Urban Development Authority, they directed to restrict such work, and on the basis of the decision taken in the meeting dated 23/2/2005 chaired by the minister in charge, the work was suspended. Since such stand was never taken earlier, either in the pleadings or at any stage of the arbitral proceeding, either by producing records or in the affidavit of evidence or during deposition or even at the time of argument, this tribunal did not permit the respondent to take such new stand.
Mr. Kundu, Mr. Joyanto Mitro's matter is fixed at 12:15. Hey, দেখো দাও 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 we'll see the এটা যেগুলো শুনছি priority দিয়ে দিই। Roughly how long you will take, Mr. Kundu?
It will take some time because
No, we are not rushing you, just trying to assess.
today I was expecting to argue for an hour. Similar.
Next Tuesday, 12:15. Mr. Kundu, our time দিও না শুধু। Mr. Kundu, learned senior counsel representing the appellant resumes his argument but does not conclude. Stop. Paragraph on the request of Mr. Kundu, let this matter be listed again on Shamner Mongolware date daw, marked 12:15 p.m.
All right.
Hey.
আমি আমার কাছে নতুন বই রয়েছে। রিপোর্ট একটা করে এই যে এইটা কতজন সেকশন না না কিছু কোনো চুপ করে
This is subject.
Yes, may it please your lordship, my lord. My respectful submission is this, that City Civil Court Act 1980, after the 1980 amendment, has made it quite clear, insofar as the cause of action, if it arises within the city of Calcutta, then by reason of the operation of section 300, read with the City Civil Court Act, read with the clause 34 of the latest patent, High Court will have no jurisdiction. That is for certain, in respect of testamentary matter. And my lord, insofar as if the cause of action does not arise within the city of Calcutta, and if, my lord, the testator was not resident within the city of Calcutta, then, my lord, wherever the property is situated, it doesn't make any difference. High Court will have jurisdiction by reason of clause 34. That will be my respectful submission. Clause 34,
Concurrently with the district courts, relevant
With
district
the
courts.
district. That means the litigants will have a choice whether to go to the district court or to come to the High Court. My lord, this is my reading of the. Therefore, my lord, I will not trouble your lordship with anything more on this aspect of the matter. Excepting this, my lord, I would request your lordship kindly, in so far as the matter in which I am appearing, the testator was outside. The properties were outside.
Rashbiari Avenue and Delhi.
And, my lord, the beneficiaries under the will, and, my lord, the persons who would have, my lord, inherited the properties in case of intestacy, they have all agreed, signed the will, I mean, the application for probate, and have given consent to it. Now, in a situation like this, I personally did not think that it was necessary for the learned judge to go into a sort of a long discourse on various aspects of the matter. The point before your lordships in this case, I don't know about the other cases for which, my lord, various learned counsel are waiting to make submission. In the facts of our case, which was argued by the court, I think, my lord, his lordship forgot what I submitted. And because there is not a whisper about my submission in the entire judgment. The judgment had gone on a, if I may use the expression, on a frolic of its own, into various things, judgments which are cited, judgments which were not cited. In fact, my submission had been this, that look at clause 34 of the latest patent, look at the City Civil Court Act. This court will have jurisdiction to entertain the proceedings. If this court has jurisdiction, then High Court rules will come into operation. If the heirs of the testators and the beneficiaries, they all agree, sign consent application, then no citation is required. If no citation is required, section 283 has got no application, and then, my lord, the probate is to be granted. Then the court asked me the question. Court said that supposing you have got the property was in Delhi. This is the directly question was asked of me. A property is in Delhi. Supposing there is somebody who is interested in that property. Now he won't know. These persons have signed. I said, after the probate is granted, section 263 is there.
Revocation, yes.
Revocation is there.
No, I don't think we have seen the order impugned.
Yes, I am going to.
So, yeah.
I'm going to place it before your lordship now. Your lordship will please to take the stay petition.
Memo.
Oh, very well, memo. This is the impugned judgment is annexed to the memo. There are certain portions I have not been able to follow. By and large, the learned judge has gone the right way, if I may say so, with respect. It starts at page 11 of the Memorandum of Appeal.
Yes.
There is a stay petition. The court has started, my lord. The opening sentence is the correct one. A short but very important point of law has fallen for consideration in this bunch of non-contentious probate proceedings, wherein the concurrent jurisdiction of this court under section 300 of the Succession Act as to whether the provision of section 283(2) of the Indian Succession Act is a mandatory provision. Now, I pause here for a moment. This is not the issue. Concurrent jurisdiction of this court, my lord, this was not the issue at all in my matter. There was no concurrent jurisdiction at all under section 300. Then section 283 has been quoted, and section 283, my lord, as I showed to your lordship, 283(1) says, issue citation calling upon all persons claiming to have interest in the estate of the deceased to come and see the proceedings before the grant of probate or letters of administration. The citation shall be fixed in some conspicuous space in the courthouse. And 3 is where any portion of the assets had been stated by the petitioner to be situated within the jurisdiction of a district judge in another state. The district judge issuing the same shall cause a copy of the citation to be issued to such district judge, who shall publish the same in the same manner as if it were a citation issued by himself, and shall certify such publication to the district judge. Learned judge was pleased to rely upon the subsection, and they said that a copy of the citation has to be sent to the district judge in Delhi, in which the property is situated. And when this issue came up for discussion before the court, I told the court, I showed my lord the High Court rules. I said that it is not necessary. Citation need not be issued. To who do I issue the citation? Citation has to be a person on a person. Citation is not to be on a property. A person is to be cited. Come and oppose this. Now, there is, if everybody agrees, then the court said that supposing there is a creditor, supposing there is some heir which is not known. Now, if he objects, then what happens? I say he will come under section 263. He will come to the court and say that, look, citation has not been issued. It is defective in material substance, and therefore the probate is to be set aside. So it seems, my lord, that was not considered at all in this judgment. Anyway, in order to examine the application of section 283(3) of the Act, kindly see, of the 25 Act in a more effective manner, it is necessary to understand the jurisdiction exercised by this court while granting probate or letters of administration at the present. The concurrent jurisdiction of this court, as envisaged under section 300 of the 1925 Act, is set out hereunder for ready reference. Section 300 has been quoted, which says the High Court shall have concurrent jurisdiction. This High Court
Yes.
Then, my lord, after section 300, clause 34 has been quoted. And clause 34, since it is there, if I may just draw your lordship's attention to the wide, my lord, amplitude of this particular provision. And we do further ordain that the said High Court of Judicature at Fort William in Bengal shall have the like power and authority as that which may now be lawfully exercised by the said High Court in relation to the granting of probate of last wills and testaments and letters of administration of the goods, chattels and credits, and all other effects whatsoever of persons dying intestate, whether within or without the Bengal division of the presidency of Fort William, provided always that nothing in these letters patent content shall interfere with the provisions of any law which has been made by competent legislative authority for India, by which the power is given to any other court to grant such probates and letters of administration. So, my lord, my submission is this, that this is not unlimited. There is a restriction in the clause itself. So, if a legislature competent to, my lord, formulate any legislation, make some law which, my lord, encroaches into clause 34, that is permissible, and that's exactly what happened in case of, my lord, the Civil Code Amendment Act. Prior to the enactment of 1925 Act, the substantive law which governed the probate and letters of administration, I'm not troubling your lordship with this. Then para 3 is important. This court, prior to the promulgation of Civil Code Act 1953, which took place in 1st September 1953, and even thereafter, till amendment of the West Bengal Act 60 of 1980 was brought to the second schedule 1953 Act, was exercising the testamentary and intestate jurisdiction under clause 34 of the latest patent by virtue of the provisions of section 2BB of the 1925 Act, wherein a judge in the original side of this court was exercising the jurisdiction of principal civil court of original jurisdiction, which has been substantially taken away by 1980 Amendment Act brought in the second schedule of 1953 Act. Well, I will submit to your lordship that perhaps this is not quite correct, because, well, my submission is this, that the High Court, this court, it says, this court prior to promulgation of Civil Code Act was not exercising testamentary and intestate jurisdiction jurisdiction under clause so and so by virtue of provision of section 2BB of the Act, wherein no, it is not under section 2BB of the Act of section. Kindly see section 2BB of the Civil Code Act.
No, of the I is Succession Act.
Sorry.
Succession Act.
Succession. Kindly see section 2BB. Kindly see section 2B. District judge means the judge of a principal civil court of original jurisdiction. But, my lord, my submission is this: prior to the Civil Code Act, the High Court was exercising jurisdiction under clause 34. It is not because of section 2BB. Clause 34 was, my lord, larger than life. That was there on the statute book. Anyway, this is what it says, my lord. This judgment says, was exercising jurisdiction principal civil court of original jurisdiction, which has been substantially taken away by 1980 amendment brought to the second schedule of 1953 Act. This position was first elaborately discussed in 1984 2 Calcutta High Court Notes, page 99, and further clarified in 2006 2 Calcutta Law Journal, page 460. I shall show to your lordship, my lord, what this judgment say. In Probate Kumar Das, there is a second judgment. A coordinate bench of this court clearly held that after the Civil Code Amendment Act 1980, the High Court, that is this court, cannot exercise jurisdiction by virtue of clause 34 of the latest patent in cases of testamentary or intestate jurisdiction in respect of matters arising exclusively within the territorial jurisdiction of the Civil Court. That is to say, where the deceased had a fixed place of abode within the ordinary original civil jurisdiction of this court, and all his assets and properties were also located in there. But nobody is disputed. This is the correct.
Correct.
This is correct. Absolutely correct. No exception can be taken to this. In order to explain the position, an example was given where a deceased had a place of abode outside the jurisdiction of the court, but had some properties and assets within the jurisdiction of this court. Then this court can entertain an application for grant of probate or letter of administration exercising concurrent jurisdiction under section 300 of the 1925 Act, but not as principal civil court of original jurisdiction. Same will be the situation where the fixed place of abode is within jurisdiction of this court, but assets and properties are partly within and partly outside the jurisdiction of this court. The position has been further elucidated by division bench in 2012 Calcutta, page 7. And that paragraph has been quoted. After the amendment of Civil Code Act in the year 1980, the provision for grant of probate under the Indian Succession Act has been totally taken away from this court and has been conferred upon the Civil Court, notwithstanding the provisions contained in the latest patent and consequent rules made in the original side. This paragraph is confined to properties within city.
Must be.
It is not that, but the
Must be.
entirely it has been. So, my lord, I feel, my lord, this is, one has to read this in the context of City Civil Court Act, read with clause 34 of the latest patent, and, my lord, Indian Succession Act. The division bench has also been given certain examples in para 21 thereof as to where this court can exercise power under clause 34 of the latest patent, read with original side rules of this court. Then 21 has been quoted. After hearing the learned counsel for the parties, we find substance in the contention of Mr. Bachawat that so far probate of the will executed by a Hindu is concerned, the same can be applied for only under the provisions of the Indian Succession Act, and there is no other provision of law now prevailing in this country for dealing with such application. No, my lord, this excerpt has been, my lord, is out of context. It has been taken. I don't think this can't be correct. The same can be applied for only under the provisions of Indian Succession Act, and there is no other provision of law. Then, my lord, para 4. Thus, after introduction of 1980 amendment, this court, except in certain cases where in respect of probate of a will over which 1925 Act has no application, only exercise original jurisdiction. Otherwise, it only exercise concurrent jurisdiction vested in it under section 300 1925 Act, and not the jurisdiction originally vested unto it under clause 34 of the latest patent. Well, may I read it again? I could not really understand the meaning. I really could not follow what it said. I have made a query mark up by the side of it. This court, therefore, while exercising concurrent jurisdiction, is clothed with the power and limitation of a district judge as under 25 Act. I don't see what is the relevance of this. In the light of the aforesaid, if one looks into the provisions of section 273 of 1925 Act, it is also clear that this court, while exercising concurrent jurisdiction after amendment of 1980 to the Civil Court Act 1953, is exercising jurisdiction not as a high court under the proviso A thereunder, but that available to a district judge under proviso B thereof. Thus, the restriction imposed to the jurisdiction of the district judge is also applicable to in the case where the High Court exercises concurrent jurisdiction. My lord, I could not follow. Kindly see, my lord, section 273, Indian Succession Act. Section 273 of the Indian Succession. Of course, it was not necessary for my application to be decided to consider all this. But then again, the learned judge has done it. But I tell you, Lordship, the problem, the practical problem. After this judgment was delivered, my lord, not one application, my lord, by the advocates on records, my lord, are sitting over here. Not one application the registrar is accepting for probate. All the applications are waiting for a clarification of this. The registrar of this court is saying that this court has no jurisdiction, therefore I will not entertain your application. So all these are, my lord, lying, my lord, in heaps in the court. And, my lord, he has further said that if
filed previously, those are not being permitted to be listed also. So prior to that order of January 2025, all the applications filed, those are not being listed also.
This particular application of mine, in view of this judgment, my lord, the registrar is saying go to Delhi and obtain probate. Not here.
We'll clarify.
Lordship. Kindly see section 273. I don't know how this is relevant really. In the light of the aforesaid, if one looks into the provision of section 270, it's clear that this court, while exercising concurrent jurisdiction after amendment of 1980 to the City Civil Courts Act, is exercising jurisdiction not the High Court. The High Court is not exercising jurisdiction, concurrent jurisdiction. Once, my lord, it is found that this particular section, section 5, applies in respect of a property which is situated within the jurisdiction of this court, Immediately, my lord, the High Court says, wash its hands off. I don't have any jurisdiction. Section 300 is no longer available to me by way of concurrent jurisdiction. So therefore, I don't know, section 273 is conclusiveness of probate or letters of administration. Probate or letter of administration shall have effect over all the property and estate, movable and immovable, of the deceased throughout the state in which the same is or are granted, and shall be conclusive as to the representative title against all debtors of the deceased and all persons holding property which belongs to him, and shall afford full indemnity to all debtors paying their debts and all persons delivering up such property to the person to whom. This is the effect of, my lord, a grant of probate of the letter of section 273. It says that if once a probate or a letter of administration is granted.
Just now, what you read is section 273 or from the judgment?
No, from the 273, because 273 has been, my lord, in this particular paragraph, section 273 has been referred to for the purpose of saying that the court, while exercising concurrent jurisdiction, I don't know how this issue arises out of section 273. 273 says conclusiveness of a probate. Once a probate is granted, then it is effective in the entirety of the state. And in respect of the property, conclusive as to the representative against all debtors of the deceased, all persons holding property. This is, my lord, this section 273 is an expression, legislative expression, that, my lord, a probate, granting of probate is my lord, an exercise of jurisdiction in rem. This is exercise in jurisdiction. That is what has been stated in section 273. Therefore, my lord, section 273, how it's the exercising jurisdiction not as a high court under the proviso A thereof, provided that the probates and letters of administration granted by a high court or by a district judge, where the deceased at the time of his death had fixed place of abode, situate within the jurisdiction of such judge, and such judge certifies the value of the property, shall, unless otherwise be directed to the grant, shall have effect throughout the other state. My lord, in this connection, your lordship will please consider also clause 34 in respect of the Chartered High Court. Chartered High Court, my lord, has got a specially, my lord, the probate, if granted, if I read it correctly, I don't know whether I am reading it correctly or not. Once a Chartered High Court, my lord, grants, my lord, probate in terms of clause 34, then, my lord, this is in respect of whatsoever person dying in state, whether within or without the Bengal division of the presidency at Fort William. This is a special, I should say, jurisdiction of the High Court, Chartered High Court, where, my lord, whether it is within or without Bengal division of the presidency of Fort William, my lord, this particular power has been given under clause 34. Unless, of course, your lordship reads that this clause 34 has been curtailed by section 273. 273 says, by a high court or by a district judge, provided that the probate and letter of administration granted by a high court shall, unless otherwise directed by the grant, have the like effect throughout the other states.
It is not, 273 is not the source of power at all.
Right.
Clause 34 is the source of power,
That's right.
as curtailed by the City Civil Court
Your
Act.
lordship. Then, my lord, kindly come back to the judgment. I was in paragraph 6, then paragraph 7. This also nullifies the view of the single judge of the Delhi High Court expressed in AI 1985 Delhi 453. High Court under proviso A of section 273 will mean only where the High Court is exercising its jurisdiction as a principal civil court of original jurisdiction and not the concurrent jurisdiction under section 300 of the 1925 Act. The learned judge was considering the effect of City Civil Court Act on, my lord, that's Indian Succession Act. So, my lord, when doing that, the court has come to a clear conclusion that by reason of section 300 having been omitted by the City Civil Court Act, concurrent jurisdiction is gone. So the court should have left it at that. Concurrent jurisdiction in respect of the properties and effects. Leave to other things. Well, kindly in this connection, see our High Court rules. One rule I just wanted to show to your lordship, chapter 35.
Rule 9.
Rule 9, and also kindly come to rule 13. Rule 13 and 14. Grants limited to state of West Bengal. All grants of probate and letters of administration with or without the will annex other than the grants under the Administrator General's Act shall, unless otherwise ordered, be drawn up by the registrar with effect within the state of West Bengal. And then 14. Grants throughout the Union of India, in all cases under the Indian Succession Act, in which it is sought to obtain a grant of probate or letter of administration with or without the will annexed to have effect throughout the Union of India, or under Administrator General's Act with effect throughout any or all the states other than the state of West Bengal, such grant must be expressly asked for, and it must be shown where the assets are situated. So if the assets are situated outside, then the court grants the, my lord, the grants probate in respect of a will of that, and with an express, my lord, with an express provision that it will have effect on the assets which are situated outside. So, my lord, if a property is situated outside in a Delhi, then, my lord, when a probate is granted by this honorable court, in terms of these I will submit to your lordship, chapter 35 of the High Court rules is really an expression which, my lord, strengthens the submission with regard to clause 34. It gives, my lord, all over India. If a specific statement is made that this will have effect in respect of a property situated in Delhi, then it will have effect that way. And this grant throughout the Union of India is being given in terms of clause 34. And then, my lord, section 273, the learned judge is saying in this paragraph that, kindly come back to paragraph 6. It says that in the light of the aforesaid, if one looks into the provisions of section 273 of the 1925 Act, it is also clear that this court, while exercising concurrent jurisdiction, court is not exercising concurrent jurisdiction after the amendment of 1980 to the City Civil Courts Act, is exercising jurisdiction not as a high court under proviso A, but that available to a district judge. Why? Why? To kindly come to section 273, provided that
These are completely unnecessary.
Completely unnecessary, but well, wrong interpretation. Kindly, my lord, come to once the proviso to section 273. I'm just as a matter of interest, provided that probates and letters of administration granted by a high court A or by a district judge, where the deceased at the time of his death had a fixed place of abode, shall, unless otherwise directed by grant, shall have effect throughout the other states. Now, my lord, so far as the district judge is concerned, there is a restriction with regard to the extent of his jurisdiction. But so far as the High Court is concerned, it has been left alone. So, my lord, clause 34 comes in. Then, my lord, learned judge is wrong in saying that when the High Court is exercising jurisdiction in terms of section 273, it is exercising jurisdiction not as a High Court, but as a district judge. No. High Court has been specifically said, and district judge has been specifically.
Yes.
And then, my lord, paragraph 8, to summarize this, kindly see the summary. I will respectfully submit to your lordship, kindly clarify the position in the light of Shailendra Sarkar's case. That completely clearly says what it is. And, my lord, the judgment of Mrs. Bhaskar Bhattacharya, the division bench judgment, that also clearly says what it is. These things are, my lord, addition and alteration of. Kindly see, to summarize, since the judge in the original side is not exercising the jurisdiction as a principal civil court of original jurisdiction, while exercising concurrent jurisdiction under section 300 of the said judge cannot grant probate or letter of administration having effect over all properties and assets, both movable and immovable, constituting the estate. It should be throughout the other state, irrespective of its value, unless otherwise directed by the grant. Well, I don't accept this. I don't accept this. This is not correct law. Then, my lord, kindly see 9, para 9. The provisions of Rule 13 and 14 of Chapter 35 of the original side rules of this court will also not permit issuance of probate or letters of administration in respect of properties throughout the state or the union of any value, where the court is not exercising jurisdiction under clause 34 of the letter special. I could not follow what it says. Why should the court not exercise jurisdiction under clause 34? What is the meaning of where the court is not exercising jurisdiction? As also in view of provisions of Substantive Law 1925 Act. Yes. Then section 283 has come. And see, my lord, kindly, section 283 your lordship has seen. And it says the section 283 powers of a district judge.
Excepting clause 34, under which law can the High Court exercise jurisdiction?
Well, I should say, my lord, the High Court, clause 34 is the source of power.
Absolutely.
Clause
What
34
section 300 clarified is that the jurisdiction that the High Court has will be concurrently exercised.
And that, my lord, by reason of city civil court
has been
taken away.
So therefore, the exercise is necessarily under clause 34.
Exactly.
So no question of where it does not exercise.
No. There is no other power of the. It seems when the learned judge has, my lord, identified the High Court with a district judge, but everywhere district judge has been said to be district judge. Kindly note against, kindly come to section 273, very clear, 273B, provided that probates and letters of administration granted by a High Court, and then B is, or by a district judge where the deceased at the time of his death had fixed place of abode situate within the jurisdiction of such judge. That means district judge. That means, if, my lord, the property is situated in Murshidabad, the learned district judge will have jurisdiction to do that. And if he does, then, my lord, it will be the place of abode within the jurisdiction of such judge. This restriction is not there insofar as High Court judge is concerned, excepting, my lord, the city of Calcutta. City of Calcutta has been carved out, and rest of it. Therefore, my lord, if there is a property in Malda, or the testator was a resident of Malda at the time of his death, then, my lord, along with the district judge of Malda, the High Court will also have a jurisdiction. That concurrent jurisdiction has not been taken away. The legislatures were quite aware of the fact that the High Court is exercising concurrent jurisdiction with all the district courts, because it is the High Court.
Given the nature of the impugned order, what do you want us to clarify? We don't know what to clarify.
But I will submit to your lordship that at least this has to be said, my lord. I will only place it this way. Kindly follow the earlier judgments which are there. I am not saying, my lord, nobody has questioned the earlier judgments. Kindly see Shailendranath Sarkar's judgment, Praveer Kumar Das's judgment. These judgments, my lord, are clear. But there is no confusion. There was no, my lord, my lord, this 1984 2 Calcutta High Court note, Shailendranath Kumar Sarkar, my lord, that is at page 14. paragraph 3 of this impugned judgment, that is the judgment of Mrs. R.N. Pine, very clearly, my lord, stating as to what the facts are, and exactly what I'm submitting to your lordship. That by reason of the City Civil Court Act, specifically some power has been curtailed of the High Court under clause 34.
Let us do this, Mr. Mitru. What we'll do, we will note the observations made by the learned judge,
Lordship.
which according to us are not correct. We will state the correct proposition which we think is correct, and that will clarify.
My lord, that is absolutely necessary, because otherwise, my lord, the entire proceedings are stalled in the department.
283 point target judgment, so that has to be clarified afresh. It says that 283 is a mandatory provision.
The mandatory provision, the body.
But then when there is no citation in the first instance,
Then, my lord, time. This is also, I don't know. Nobody has cited this judgment. This judgment has come up. Kindly come to para 18. This has created a lot of problem, man. In 1925 Act, though the word citation has been in various sections, but does not qualify the same either as general citation or special citation. It is only in Rule 10 and 11 under Chapter 35, the original cite rules of this court, that there is mention of general and special citation. General citation is to be issued to all persons claiming to have any interest in the estate of the deceased, which is normally directed to be published in the newspaper. Special citation, on the other hand, is to dedicated persons required to be cited under Section 283(3) of the 1925 Act. The citation will mean the general citation. Now, my lord, I pause here for a minute. This is absolutely correct. So, special citation and general citation has been mentioned in Rule 10 and 11 of Chapter 35. Now, coming to the two judgments of the Honorable Supreme Court reported respectively in 2008, one Supreme Court cases 267, Bashanti Devi, and 2018, one Supreme Court cases, Lynette Fernandez, which have been cited at the time of hearing. I did not cite. I don't know. Anybody cited this? Huh? Well, we did not cite it. Which have been cited at the time of hearing. It is found that both the judgments were delivered in the context of revocation of grant. Correct? Absolutely correct. No application under Section 263 of the 1925 Act. In Bashanti Devi, the Honorable Supreme Court, after considering the provisions of Section 283(3) of the 1925 Act in the context of revocation of grant, has clearly held that the provisions of Section 283(3) of the 1925 Act is mandatory, and non-compliance thereof will lead to revocation of grant. In Lynette George Fernandez, the application of revocation was made after 36 years. The single judge, as also division bench of the concerned High Court, declined to revoke the grant for non-compliance of the provision of Section 283(3) of the 1925 Act. As on the facts of the case, it was observed that issuance of citation at a particular place was not fatal, as it did not affect the right of any person. I am unable to accept the ratio laid down in Lynette Fernandez. As the revocation stage, it may, on a consideration of the facts of the case, the court may find that non-issuance of citation as required under Section 283(3) of the 1925 Act may not be fatal. But at initial stage, that is at the time of grant, the provision of Section 283. My lord, the court, this is a very convoluted judgment. My lord, we get lost, my lord, in the verbiage. Will be fatal and not a mere error. Moreover, it did not take account of the ratio laid down in Bashanti Devi, which clearly held that the provisions of 283(3) of the Act. If it is 283(3) is mandatory, I proceed on the basis it's a mandatory. Then, my lord, if it is not followed, Section 263 comes into operation, you set aside. Because, my lord, there is a fundamental irregularity in the matter of hearing of the probate application. That will not have any, Section 280, if the learned judge is right, and I say it is right in paragraph 18 with regard to general citation and special citation, it is in respect of persons. General citation is to be issued to all persons claiming to have interest. Special citation to particular persons claiming to have interest. Now, if there is no person to be cited because everybody is agreeing, then my lord, I don't know how a copy could be sent. And the language of the section 283 is this: a copy of the citation to be issued is to be affixed. Your lordship sees, my lord, the language of section 283. It says, where any portion of the assets has been stated by the petitioner to be situate within the jurisdiction of a district judge in another state, the district judge issuing the same shall cause a copy of the citation to be sent to such other district judge, who shall publish the same in the same manner as if it were a citation issue. Even assuming the High Court judge is a district judge, for the purpose of Indian Succession Act, even assuming that, a copy of the citation is to be sent only if a citation is issued in terms of subsection 1 B.
Deferred for this matter, I did before this. Okay, deferred for this was passed before. Should have been. We cannot pass this because one point.
ছেড়ে দাও ডিভিশন বেঞ্চের কাছে এসছে, the division bench.
Yes, Mr. Mithru, anybody wants to add anything, or we should straight away?
Well, I think, my lord, this is the
Yes.
crux of the matter I have told your lordship.
Only your matter is before us. Are your matters before us? No. So we will, Mr. Mukherjee, we will let us deal with this. We'll clarify all the ambiguities or what we think is not the correct position in law as has been observed. And that will help you in all the matters.
My lord, in 73, when the High Court has been considered, it's only the High Courts by the chartered High Courts. Because my lord, the lordship sees 213, which 57, probate is granted only probate of bill. It's only applicable to Bombay, Madras, and Calcutta. We repeat that. So when High Court is being considered, it's only the chartered High Courts which are being considered. So the source actually comes from 34 and other relevant clauses in the other chartered.
Correct.
Only source. Yes.
The High Court being considered is only the chartered High Courts also, not the other High Courts. That's what I just want to say. The lordship reads 213 with 57. That's the logic. Other courts, probate is not necessary.
In other courts, probate not necessary. Yes, you're right. You're right.
So that's why the lordship sees 213 read with 57. When High Court is being considered, it's only the chartered High Courts.
Read with 57.
Yes, and the Supreme Court judgment also on that point.
213 of the Succession Act.
Yes, 213 read with section 57. If there is a will which is being executed within the chartered High Courts or property within the chartered High Courts, only then probate is necessary. Otherwise, probate is not necessary at all. So therefore, my lord, when High Court is being considered under any other provision, where like 273, it's the chartered High Courts only which is being. So to equate the High Court with district judge is absolutely.
Yes, Mr. Kaur, you want to add? Yeah, sorry. Have you concluded?
But I only addressed on the point, what is concurrent jurisdiction? Because the learned judge has held that concurrent jurisdiction means High Court is exercising the jurisdiction of the district court. That is not correct. Because in Black's Law Dictionary, the word concurrent jurisdiction has been defined.
Sorry.
Milord, may I read it and then hand it over to your lordship? Yes. Only one copy, that is my. Concurrent jurisdiction means jurisdiction that might be exercised simultaneously by more than one court over the same subject matter and within the same territory. A litigant having the right to choose the court in which to file the action. It's not that jurisdiction is being exercised by the High Court of the district judge. It is the litigant's choice.
No, Mr. Kaur, that's what we said. The jurisdiction the High Court exercises under clause 34 concurrently with the district court. That is what we said.
My lord, if your lordship,
We will look it up. We have noted. We have noted.
that I am quoting from 10th edition. my lord.
Which year? 10th edition?
Lordship will give me a minute.
How much does a copy of Russell on arbitration cost now? 15.
But there's the
50.
Indian edition now, which is cheap.
Oh, I
There's
see.
the Indian reprint. Indian reprint, which is cheap. The
Original is
original one is 50 plus.
50,000.
10th edition.
One volume.
বছরে চাইছে।
Not now the Lloyd's law report.
That is what is arbitrary. Russell on arbitration.
My lord, may I hand up my
The
copy? my
Indian
lord?
reprint is actually
May I hand up my copy? my lord?
Your copy, no, not necessary. We have noted. We have noted. Very well. We'll pass order. We are
the Indian reprint is 4,700 and the original is 360 pounds.
360 pounds. Close to 40.
My lord was hearing item number 62. My lord, item number 63 is also tagged with item number 62 involving the same point of law, my lord. I am adopting
It's a common judgment. But I mean,
No, my lord. Based on the judgment impugned in item number 62, the order in my matter.
63 to dekhi.
Item number 63 kindly sees, my lord.
Supreme Court which says under 213 and 57.
Chartered High Court.
Chartered High Court.
Give it.
I'll give it.
When will you give? Today?
My lord will kindly see the order impugned is dated 10th of March 2025 and it has been passed on the basis of the order dated 16 January 2025, which was item number 62 before my lord. So my lord, item number 62 and 63 were tagged together.
Very
Sir,
good.
I adopt the submission.
Both একসঙ্গে নেবে এটা 62 and 63 করে দাও hearing is concluded. Stop. List these matters under the heading for orders on আজকে 11 তো
It is 12th. my
12
lord.
August 26
26.
August 26
I'm grateful to my lord.
26 August পাঠিয়ে দাও আমার কাছে ওই আরেকটা সর্বপ্রিয় একটা কপি দেবে ওইটা শুদ্ধ একসঙ্গে নিয়ে পাঠিয়ে দেবে
It's not necessary in other jurisdictions. Probate, that's what it says. It doesn't say
এটা কি আপনার?
I know for sure in Kanpur it's not necessary.
57. Become very clear. Only judications of controversy where 57 says application of certain provisions to part and A, 57A, to all wills and codicils made by him which is Sikh so and so within the territories which at the said date was subject to the Lieutenant Governor of Bengal or within the original jurisdictions of Judicature of Madras and Bombay. That's where execution of will. And B is where the property is situated. And now if your lordship reads 213 with that, so this is where the wills are applicable. 213. One says that no right as executor or legatee can be established in any court of justice unless a court of competent jurisdiction in India has granted probate of the will. And then 2, This section shall not apply in case of wills by Mohammedans and shall only apply one in case of wills made by Hindu, and such wills are classes specified in A and B of section 57. So read together, Supreme Court has held that the wills which are executed outside Bombay, Calcutta and Madras, or properties outside Bombay, Calcutta and Madras, no probate is necessary. So it only considers high courts which are Bombay, Calcutta and Madras.
Correct.
I'll send you the
Philips commercial division, item number 2.
My lord, in this matter, I am led by learned senior counsel, Mr. Nilanjan Bhattacharjee. My lord, he is on his legs. I am praying for a short passover.
My lord, I have instruction to appear for in this matter, my lord. I am for the respondent, my lord. Let a copy be served upon the my lord.
Not served.
Yes. We have not served any copy, my lord.
My lord, we are
Perhaps, my lord, this is an order, my lord. Order under challenge, my lord, is arising out of a section 9 proceeding which was passed on contest. An order was passed, and thereafter section 11 application was filed by me. Arbitral tribunal has been constituted.
Has
by
been
the-
constituted.
Yes, yes.
Then
my lord, we are restrained by the order. There are certain things.
And they have acted upon the order
lord,
as
my
well,
lord,
my
please
lord.
order.
I have the communication, my lord. They have even acted upon the order.
My lord,
My lord, this is the order of passed under section 11, my lord. It was also passed in presence of the party.
my lord, by the order impugned, my lord, we have been restrained from my lord, taking any steps towards my lord, the lessee at a previous rate of rent. Though in the agreement it was stated that after a particular time, my lord, we have to collect the rent as per the government circular.
Mr. Bhattacharya, today the tribunal has been constituted. Now, what we are minded to do, this order was passed on the 22nd of, 17th of June.
Yes.
So almost 2 months have gone
The
by.
difficulty is only difficult. My lord, there are twofold difficulty, my lord, what we are facing. We are not, my lord, I can understand what is fallen from my lord.
Or if first listen to what we propose to do, only then tell us. We will limit the operation of this order to a particular period and ask the tribunal to consider whether this order should be continued or vacated
As your lord.
That is already
upon
there.
hearing both sides.
That is already there, my lord.
So we will continue 3 weeks.
My lord, the learned commercial court, my lord, in its order, my lord, said that the enforcement of this order will be continued till the constitution of the tribunal, and thereafter tribunal will take care of it. Whatever tribunal feels. Kindly see
Yes,
the
but
order.
the Mr. Problem is this order is unlimited in time.
Yes.
Can the tribunal set aside the or vary the court's order unless we make it clear?
Yes. I understand, my lord, but
Yes.
my lord, it is not that, my lord, I am enjoying the order. I have immediately taken steps. I have already, my lord,
Therefore, we are only directing the tribunal to consider whether this order shall continue or it will be vacated.
correct, my lord, correct.
Because, my lord, the main difficulty, my lord, is that we are not the owner of the land. There was an arrangement between the owner and the lessor that we will commercially exploit on a profit sharing ratio.
Lord.
Now, what happened? The order says that there was a moratorium period. Now, my lord, the order says that they will enjoy the property at a previous rate of rent. Though, my lord, from the gazette notification, the rent enhanced by the authority itself. Now, my lord, we are in the default. That is the main difficulty, my lord.
My lord, I also have a small submission, my lord, if your lordship, my lord,
We are
kindly
not
permits.
going into the merits of the case. Why are you addressing the merits?
No, my lord, since, my lord, your lordship is daring, I am also, my lord, I am also in hurry. because of the issue, my lord, despite of this order,
We are also in a hurry to dispose this off.
my lord, only one line, my lord. Because despite of this order, my lord, we are not able to operate business, my lord. We have not been provided any access.
No, it's
That we
absolutely
can't do anything.
Yes, yes, my lord.
absolutely.
My
my lord,
learned friend is
Yes,
talking
sure.
about rent, but he's not providing place to me.
This appeal is directed against an order dated June 17, 2025, passed by the learned judge, commercial court at Alipur, in Miss Arbitration bracket closed 23 of 2025. Top. No, 25, filed by the respondent herein.
Yes.
Stop. The operative portion of the said order reads as follows. A Meredilum sticker. The ordered J portion touch. Paragraph being aggrieved, the respondent in the section 9 application has come up by way of this appeal. Oh, এখানে যেখানে বললেন না মিসকম আমি তারপরে কি বলেছি মিসকম তারপরে এখানে অ্যাড করে দাও কমা তারপরে ফাইলের আগে being an application under section 9 of the Arbitration and Conciliation Act, 1996, বলে তারপরে filed operative portion হয়ে গেল. 9 application has come up by way of this appeal. Paragraph. We are told that after the passing of the order, on an application made under section 11 of the 1996 Act, an arbitral tribunal has been constituted by this court. This court?
Yes.
Stop. We therefore refrain from entering the merits of the case. Stop. Paragraph. We direct the learned arbitral tribunal to consider whether or not the interim order that has been obtained by the respondent in this appeal should continue, whether or not the interim order or any portion thereof which has been obtained should continue. Stop. This the tribunal will do naturally after hearing both parties. Stop. Such a decision should be taken within 3 weeks from the date of communication of this order by the parties to the learned tribunal. Stop. The interim order passed by the learned trial court shall continue till a decision is taken by the learned tribunal in this regard.
Good.
Paragraph. We clarify, we have not gone into the merits of the case at all. Stop. The learned tribunal shall take an independent and informed decision in accordance with law, without being influenced by any observation in this order or in the order of the learned trial court.
Kindly direct the appellant matter to serve copy.
I gave him a copy. He doesn't have a copy. Application, appeal connected application.
দেখি আপনারা কি লিখেছেন ওর মধ্যে।
কপি আমি সব সেকশন 9 এ তো এফিডেভিট কমপ্লিট
হ্যাঁ no
মানে since the
No, no.
pleadings has already been complete in section 9
my
application.
lord, I have to file a
Section
claim.
9 he has to file fresh
Statement of
application.
claim,
No,
my lord.
statement of claim is different. What I'm praying, my lord, so far as the section 17 part is concerned, since the pleading has already been completed.
That may be treated as.
Yes, my lord, because
তাই কারণ আবার দেরি হয়ে যাবে। একটা জায়গায় অ্যাড করবে, দেখি কি পারো কিনা। The tribunal shall consider the pleadings, shall treat the pleadings that the parties had filed before the Section 9 court
Yes.
as pleadings filed before the tribunal for the purpose of deciding whether or not the interim order should continue.
My lord, in that event, my lord, there is only one difficulty, my lord. After passing of the order, there are subsequent events and correspondence are there, my lord. So liberty should be given. Subsequent events should be put in by way of a supplementary affidavit or any.
No, when will you put it? We'll give you 5 days time or something.
Within a week.
Within a week.
Yes.
No, but then we should give 3 weeks clearly to the arbitrators.
Yes.
তাহলে আবার পাল্টাতে হবে। Parties will be at liberty to file pleadings before the tribunal, supplementary pleadings before the tribunal, to bring on record developments that have taken place subsequent to passing of the order by the learned trial court. Stop that. The same may be done within a week from date. তারপরে আর্বিট্রেটরকে 3 সপ্তাহ দেবে। ঠিক আছে, বুঝতে পেরেছো?
Grateful.
Appearance.
Number 3.
Wow. Almost concluded.
My lord, few judgments, and then, my lord, should
What
I
is
also,
your
my lord,
concept of few, Mr. Bag?
3, my lord.
3.
3, my lord.
That is okay. Okay, all right. Tolerable.
Perhaps I'll also cut down to 2, not 3,
That is even better.
my lord. And, my lord, may I also, my lord, make submissions on the other points today, my lord? I want to conclude.
Yes, conclude. Please conclude.
This is only on the point of maintainability, my lord, the 12.5 point, because,
Yes.
my lord, it had fallen from your lordship that if this is the point in which you, if you succeed, then we'll not hear the other points. So, my lord, if I conclude this, and my lord, I'll also then shift to the other points that I have. I have filed a notes that it has all
Do
the.
not shift, because as of now, you're unlikely to succeed on this point.
That's the reason. Then I'll shift to the other points also which I have. Because once I conclude this submission. If I do not succeed, my lord, because I'm the appellant here. So, my lord, if I do not succeed on this point, then, my lord,
You've attacked the award on other grounds also.
on other grounds also. And they are all, my lord, I file a notes. It's a skeleton note of submissions which I filed, my lord.
Yes, but whatever it is, please be brief.
We
You have filed the notes, we'll consider all those points.
I'll quickly indicate, my lord, the points, and then I'll conclude. At this point, I'll not take up much. I'll quickly recap, my lord. The point was that in the agreement, the arbitration clause which was contained in the
Statutory
GCC 2001,
modification.
Statutory modification. But the law, as it stands, it says that Section 26 of the Amending Act, that this will not apply to any arbitration proceeding which has been initiated prior to the amendment. My case is not merely. Now the distinction, my lord, my case is not in the nature of a proceeding which has been initiated prior to the amendment. Had that been the case, that is what is guided by Section 26, my lord. My case is different because here there has been a reconstitution which has not been dealt with in Section 26. Reconstitution per se has not been dealt with in Section 26. Reconstitution has happened in 2016 after the amendment. This has been dealt in a judgment of Dharamveer. My lord, it's a division bench judgment of Delhi High Court. I'll refer to that. But prior to that, my lord, Ellora Paper Mills, because this judgment has been considered by Delhi High Court in Dharamveer. Hand over Ellora. Ellora, but we have handed over, my lord, Ellora Paper Mills Limited yesterday. My lord, we were referring from
Paragraph 8 starts from page 7 over the page, page 8. First paragraph at page 8, the continuing paragraph. After the judgments are cited, the part just after that. High Court has not agreed with the submissions on behalf of the appellant, referring to the aforesaid decisions of the court. It is observed and held by the High Court that the Amendment Act 2015 shall be made effective from 23rd October 2015 and cannot have retrospective operation in the arbitration proceedings already commenced, unless the parties otherwise agree, and therefore when the present case, the arbitral tribunal was constituted much prior to the Amendment Act 2015, and the arbitral tribunal commenced its proceedings, the Amendment Act 2015, Section 12(5) of the Arbitration Act 1996 shall not be applicable. Observing so, the High Court, by the impugned judgment and order, has dismissed the application filed by the appellant herein under Section 14 and 11, 14 read with Sections 11 and 15 of the Arbitration Act, and has observed that it would be open for the appellant to participate in the proceeding before the arbitral tribunal constituted by the respondent as stationary purchase committee. So this was the premise, my lord, from where the appeal was preferred. May I refer to the part where the same copy. That's just a second. Paragraph 12 is where the decision starts, my lord. We've heard the learned counsel for the respective parties at length. Having heard the learned counsel for the respective parties on consideration of the impugned judgment and order passed by the High Court, the short question which is posed for consideration of this court is whether the stationary purchase committee arbitral tribunal consisting of the officers of the respondent has lost its mandate considering 12(5) read with 7 schedule of the Arbitration Act 1996. If the answer is in the affirmative, in that case, whether a fresh arbitrator has to be appointed as per the Arbitration Act 1996. Over the page, the next paragraph, my lord, starts with it is not. But kindly take that paragraph. It may be true, my lord, the next paragraph, paragraph 14, that the earlier arbitral tribunal stationary purchase committee was constituted as per the agreement entered into between the parties. It is also true that initially the arbitral tribunal was constituted by the High Court in the year 2001. However, thereafter, stationary purchase committee arbitral tribunal could not commence the arbitration proceeding in view of a number of proceedings initiated by the appellant. There was a stay granted by the High Court from 2001 to 2017, and thereafter in the year 2019, present application was preferred before the High Court, invoking Section 14 read with 11 and 15 of the Arbitration Conciliation Act, seeking termination of the mandate of the originally constituted arbitral tribunal to appoint a new arbitrator. I pause here for a moment, my lord. It has not been in dispute that, my lord, this tribunal was constituted, my lord, prior to the amendment, and that was not set aside. The mandate, my lord, on which the premise on which 11, 15, and 14 was filed before the court was, my lord, that after the amendment, 12(5) would apply to this proceeding, where, my lord, the tribunal was constituted admittedly in 2001. Kindly see the reasoning thereafter. Paragraph 16, my lord. As observed, herein above, the arbitral tribunal consisted of officers of the respondent state. Therefore, as per the Amendment Act 2015, subsection 5 of Section 12, read with 7 schedule, all of them have become ineligible to become arbitrators and to continue as arbitrators. Section 12 has been amended by the Amendment Act 2015 based on the recommendation of the Law Commission, which specifically dealt with the issue of neutrality of arbitrators. To achieve the main purpose of the amending the provision, namely to provide the neutrality of arbitrators, 12(5) lays down that notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or subject matter of the dispute falls under any of the categories specified in the 7th schedule, he shall be ineligible to be appointed as an arbitrator. In such eventuality, that is when the arbitration clause is found to be foul with the amended provision, the appointment of the arbitrator would be beyond the pale of the arbitration agreement, empowering the court to appoint such an arbitrator as may be permissible. That would be the effect of the non-obstant clause contained in 12.5, and the other party cannot insist upon the appointment of the arbitrator in terms of the arbitration agreement. My lord, this is on the premise that the tribunal has been set in 2001. My lord, thereafter, it cannot be disputed in the present case. Tribunal comprising of officers of the respondents are all ineligible to become and continue with as arbitrators in view of the mandate of 12.5 read with 7 schedule. Therefore, by operation of law and by the amending section 12 and bringing on statute 12.5 read with 7 schedule, earlier arbitral tribunal stationary purchase committee comprising of, and the details are given, my lord, has lost its mandate, and such arbitral tribunal cannot be permitted to continue, and therefore a fresh arbitrator has to be appointed. Over the page, my lord, identical question, this paragraph 18, my lord. Identical question had come to be considered before this court in Jaipur Zilla, and after considering the decisions of this court in TRF and other decisions on the point, it was observed and held under in Ajay Sales and Suppliers case. It's quoted, my lord. I'm not troubling your lordships with the details. Kindly take up, my lord, the next part. Paragraph 19 at page 17 is where, my lord, Bharat Broadband has been quoted. Paragraph 19, my lord. There, my lord, paragraph 18 has been quoted, that after referring to decision of Bharat Broadband, it is observed and held in paragraph 18 of Ajay Sales. That part is again quoted with approval. Thereafter, my lord, is the reasoning given in paragraph 20 at page 19. They could have considered in that judgment. Give me Dharamveer.
Sure.
Dharamveer. Give it 2 copies.
Yes.
Paragraph 20. The judgments are quoted, and then, my lord, it is held after the first 5 lines, my lord. TRF and Jaipur quoted, my lord, not quoted, referred to, and thereafter, my lord, it is held that the earlier arbitral tribunal comprising of, and the details given, has lost its mandate by operation of law in view of 12.5. Now, this is referring, my lord, to an arbitral tribunal constituted in 2001 because of 12.5, because of the amendment. I'm not read with 7 schedule as a fresh arbitrator has to be appointed under the provisions of the Act. So it goes beyond that section 26, but my case is better because in my case, my lord, there has been a reconstitution which is now dealt with in Dharamveer's judgment. My lord, the reason why Vishnu construction would be, my lord, not applicable to our case is Vishnu construction was, my lord, on accord and satisfaction. 11.6a was being interpreted by the court. There, my lord, section 26 was interpreted, not in a situation where there was a reconstitution, my lord. There, my lord, the premise was that 11.6a, what if an accord and satisfaction is to be seen, then it has to be fallen back on section 21 of the original act because of section 26 of the amending act, my lord. That if the notice was given prior, then this part will not apply to a case where the notice was prior to October 23, 2015, when the amendment came into being. My case, my lord, is perhaps guided by Dharamveer, and I'll indicate why. My lord, here, after this, my lord, paragraph 20 in the next paragraph, after the discussion, my lord, a fresh arbitrator was appointed. That was Elora. Well, Elora being followed in Dharamveer, this is, my lord, 2024, the division bench of Delhi High Court. And this is the last judgment I'll refer to, my lord. I'll not refer to anything else, my lord. Then I'll leave it to your lordships. My lord. This was a petition which was, my lord, it was an appeal under section 37, read with section 13 of the Commercial Courts Act, challenging an award which was 2017, my lord, 17th August 2017. That's in the first and the second paragraph. Kindly see the discussion, my lord, starts from paragraph 16. This is internal page 5, paragraph 16, my lord. At the outset, this paragraph 16, my lord, at the outset, it is necessary to consider whether unilateral appointment of arbitrator by the respondent invalidates the impugned arbitral award. I'll pause here for a moment. There's a reason why I'm referring to this judgment. But I've said that there are other points which we'll be taking. The reconstitution has been done unilaterally. That's my other point, my lord. In 2016, if there's a reconstitution, that could not have been done unilaterally because by then, my lord, the amendment had come in. Even if I don't go by the amendment, this unilateral reconstitution in 2016 is, my lord, there are judgments which indicate, which, my lord, we have annexed to the notes. If, my lord, this point is not canvassed by us, that, my lord, it is a reconstitution, and whether 2015 amendment will apply, will not apply. But unilateral reconstitution of an arbitral tribunal by an entity who could not themselves be arbitrators in the matter, how far that will be, my lord, justified after the, my lord, in the light of 2015 amendment, I'll quickly indicate that. But here, my lord, undoubtedly unilateral appointment of the arbitrator is an anathema to the provisions of the Arbitration and Conciliation Act as amended by the Arbitration Conciliation Amendment Act 2015. Legal position in this regard has been authoritatively settled in terms of the judgments of the Supreme Court in Perkins, TRF, Bharat Broadband, Central Organization for Railway Electrification. They're given. Then paragraph 17. However, the moot question that falls for consideration in the present case is whether the amended provisions of the Arbitration and Conciliation Act would apply, considering that the arbitration commenced prior to coming into force of the Amendment Act. In this regard, section 26 of the Amendment Act clearly provides as under. It's quoted, my lord, section 26 over the page. Then, my lord, BCCI case is quoted. Not trouble your lordship with the details. Paragraph 19, my lord, the position which emerges from BCCI has been, my lord, encapsulated. That's, my lord, paragraph 19. Then, my lord, paragraph 23, the other judicial precedents, my lord, dealing with the applicability of the Amendment Act has been, my lord, discussed from 23 onwards. Kindly take up. And this, my lord, all the judgments are serially, my lord, indicated. Paragraph 34 is Vishnu construction. That's paragraph 34, my lord. The Elora judgment has been, my lord, discussed in details from paragraph 37. My lord, the part which I want to rely on is paragraph 42. The principle of law laid down in the state judgment clearly applies to the facts of the present case as well. Thus, after coming into force of the provisions of the Amendment Act, in the event of any reconstitution, not kindly mark this, in the event of any reconstitution of the arbitral tribunal, it is impermissible to disregard the provisions of 12.5, read with the 7th schedule of the Arbitration Conciliation Act as interpreted by the Supreme Court in Perkins, TRF, Bharat Broadband. This is what I want to place reliance on, Miller, because this is not discussed in the other judgments. What happens when there is a reconstitution? Here, admittedly, Miller, there is a reconstitution in 2016. So, in case there is a reconstitution, would section 26 of the amending act, Miller, guide the entire proceeding? Where, Miller, it is with a notice under section 21 under the original act prior to the amendment. This, my lord, discusses in paragraph 42, and the finding is rendered that if there is a reconstitution, because the other judgments are not on reconstitution, my lord. If there is a reconstitution, then the amendment after 2015 will apply. I'm placing reliance on this, my lord. And then the facts of that matter has been discussed on, and my lord, not troubling your lordship with it. This is the principle, the ratio, my lord, which I want to place reliance on.
The other points?
My lord.
উনি কি নোট ফাইল করেছেন দাও না আমাদের একবার উভয় পাশে
Only the judgments.
Are you trying to intimidate us by the volume of this?
It's only 4 pages. The others, my lord, the rest of it is judgments. And that also, my lord, we have indicated what judgments will, my lord, really place reliance on. Very few of them. My lord, I must say, I understand that your lordships are not with me, my lord, on the point.
No, we haven't yet finally
perhaps because,
decided.
my lord, I'll indicate why I, my lord, strenuously submitted, and my lord, I refer to Dharamveer, is because of paragraph 42. But because none of the other judgments, my lord, really deal with a reconstitution post the amendment. And, my lord, my case, there is no other, my lord, judgment I've searched, my lord. I couldn't come across any judgment, my lord. Where, my lord, this point is...
You see, reconstitution entails also appointment of a new person.
Indeed.
In effect, call it whatever you want to.
I'm very grateful, my lord. Very grateful.
So therefore,
that is why, my
whether
lord, in that case,
not much different. 26 should apply to, let us think about it. We may or may not agree with the Delhi division bench.
Lordship.
Yes.
The notes, may I quickly indicate, I had started with this, my lord. Brief facts, second page of the skeleton notes, which we had referred to, my lord. The page numbers are referred to.
Yes.
The impugned order, my lord, is at page 304 of volume 2 of the paper book. It's 29th of September 2021. I'll quickly indicate the facts which, my lord, volume 2, page 304. But before I request your lordship to look into the papers, I'll quickly indicate what the facts are.
Yes, to be rapporteur.
Because the points in section 37, my lord, are very limited. I'll indicate what is the real grievance, my lord. So the tender was floated on July 9, 2010. But the work was, my lord, welding of rails using railway premises at the welding plant at Jharsuguda. This page 2, my lord. This 2A. We participated, we were successful. There was a joint inspection. We mobilized our resources in November 2010. The respondent failed to provide the materials. And, my lord, we have indicated from the special conditions of contract that they were violated. They were supposed to, the railways were supposed to, my lord, provide us with existing roller line and total infrastructure in a running condition with electrical and mechanical items. Is very important, my lord, because the entire dispute is with regard to, my lord, this electrical items which were not given. And the details we have indicated, my lord, which paragraphs this is and which part of the paper book. You know, there are failures in, my lord, the wheels. The reason is fluctuation in voltage, and this, my lord, is not due to any defect in machines provided by us, deployed by us. But we requested them to rectify this. They failed to rectify it. And there was a defect in voltage of the electricity supply, and they proceeded to terminate the contract between the parties in 2011 November and invoke the bank guarantee. So, my lord, that was the genesis to the arbitration proceeding. My lord, we claimed a sum of 1,97 lakhs odd, along with interest. But over the page, the third page, my lord, the award and the glaring discrepancies in the award are culled out here. Page 272 of the paper book is where the award starts from. The appointment of the arbitral tribunal is described in paragraph 1 at page 272. Where, my lord, it is recorded, this is one of the main points, my lord. It is recorded that there were 4 hearings and the dates are given. Now, this is at page 272, my lord. May I request your lordships to take up this page once. 272 of volume 2.
Yes.
But kindly take up page 273, the second paragraph, it's marked as 1.1. And whereas the arbitral tribunal, page 273, the second paragraph, from top. It's marked 1.1. Arbitral tribunal consisting of so and so and entered into reference with both the parties on December 30, 2016. Vide letter number this. Subsequently, 4 hearings were held. Kindly note the dates. May 2017, June 18, August 18, September 18 to cover the full case. So 4 hearings, my lord, in total.
How is that significant?
Because after these dates, documents were called for from the respondent. We were never given an opportunity to deal with those documents.
I see.
And I'll show that. That's page 280. Kindly take up page 280, my lord. (5.6.1) and 5.6.2. These 5.6.1 were the documents which are called for. 1, 2, and 3. 5.6.2 on the above, the respondent submitted their compliance, vide their letter number this. Dated, kindly note the date, my lord, January 9, 2019, which is reproduced as under. So we never had a chance to deal with these documents, and these documents were considered by the tribunal in passing the award. That's the point, my lord. And hence we say that, my lord, coming back to the skeleton notes, page 3 of the notes, my lord, 3B. The glaring point, Lord, because 3B we say we did not have an opportunity to deal with the documents, and these documents were never made over to the appellant in the course of the proceeding. This is in violation of section 18 of the Act and renders the award to be set aside, liable to be set aside under section 34. The third point which we have raised is because the counterclaim of the respondent was accepted without any proof by the arbitral tribunal. No evidence led in the matter, my lord. No proof. It is a chart given by them. It's accepted verbatim. But what they have stated is exactly reproduced by the tribunal. Kindly take up page 284 of volume 2. I'll indicate, my lord. There is no whisper as to how they prove this. Merely because they've given this figure, it has been considered. That's page 284, my lord, paragraph 7. And here it is recorded. Kindly see paragraph 7.1. 7, my lord, is the counterclaim. This page 284, my lord. Paragraph 7, counterclaim of the respondent. Para 65 of respondent's counterclaim. The figure is given. And it is just accepted, my lord. Counterclaim awarded is the amount is given. There's no calculation why this amount, why not something else. And the first line is very interesting, my lord. It's records. After 7.1, the first paragraph thereafter, third line. There were faults both on the part of the respondent and the claimant, which has led to the failure of the contract. So that's the recording, that's the finding. However, arbitral tribunal has examined the other claims of the respondent, and it is observed that the respondent had to take repairing action for cutting and failed weld joints done by the contractor, and during cutting there has been wastage of rail due to cutting. The calculation submitted by the respondent for cutting of joints, cost of average rail and shifting or is found in order. How is it found in order? There is no whisper. Whatever they have given has been blindly accepted by the arbitral tribunal. Whatever figure, whatever calculation they have given. That's my other point. And these are encapsulated in paragraph 3 of the skeleton notes, A, B, C. We've done that. Now, when we challenge this in section 34, that we have encapsulated in the next paragraph, paragraph 4 of the skeleton notes. At page 4, we say we've indicated the page number. Starts from the last part of page 3 and moves over to the next page. Starts from page 39 of volume 1. Here, we have stated the points. We said, it's a violation of mandate of section 12, 29A, 18. And the grounds we have referred to, in the impugned order, paragraph 5, we have said, at page 304, that's the order in section 34. It's in volume 2, that's where the impugned order starts. Kindly see the pointers there, which we have tried to summarize. The first is the reasoning starts from page 318 in the impugned judgment and order, page 318 onwards. First is the point of reconstitution of the arbitral tribunal. Your Lordship kindly takes up that part. We have indicated this is 318. The only point in which 12, 5 and 7 schedule point was not taken was that this has never been raised before the arbitral tribunal. The Delhi High Court judgment and the Bombay High Court judgment, which says you don't need to take it up. You can take it up not even in 34. It can be taken up directly in 37. It's a point of law. So this part is wrong. This part of the impugned order is not correct. The reasoning is not correct. Thereafter, the grounds which we have raised, and we have indicated the ground numbers with regard to section 18 and 29A, have not been dealt with in the impugned order. There is no reasoning. There could have been a reasoning as to why section 18 will not apply or section 29A will not apply. They are there in the grounds. We have indicated the ground numbers. But the impugned order is silent on these grounds. Not dealt with. That's what we have stated in paragraph 5B of the skeleton notes, The next point, is a wrong recording which was made in paragraph 10 at page 323 of the impugned order. A wrong recording at paragraph 320, page 323 of the impugned order. It's been recorded. No objection was raised with regard to site condition at the initial stage by the appellant. We have tried to indicate this in the notes. 5C is the paragraph,
Yes.
This recording, is erroneous because the tribunal has observed that there were failures on both the sides. And we have also stated that the principles have been noted in page 332. And these principles have not been applied to the facts of the case because these principles were really not cited by the parties. Section 34, the basic principles have been culled out by the learned court. And without any reasoning, and the reason we raise this point is kindly take up paragraph page 325 once. Volume 2, page 325. It's a part of the impugned order. We'll kindly see the judgments which have been referred to. Paragraph 325, State of West Bengal versus Bharat Vanijya Eastern Private Limited. At page 326, Bharat Coking Coal. Only the judgments and the quotations from the judgments. KV Mohammad Zakir, PR Shah shares, page 327. But all these judgments, including my lord, Associate Builders, Steel Authority, just been referred to, my lord. And thereafter, section 34 has been quoted. And there is no reasoning given as to why, my lord, this principle will apply to the facts of the case. It's not given. ONGC has been referred to by the learned court. And a finding has been rendered at page 333, my lord, ground number 28. May I read this part, my lord? It says, the petitioner has failed to prove in the present application the decision of the learned tribunal is not fair, not reasonable, and objectionable, and that the learned tribunal has made arbitrary and whimsical decision. No violation of natural justice has been shown by the petitioner, and the learned tribunal has perfectly followed the principle, celebrated principle of audi alteram partem. The petitioner has also failed to prove before this court that there was non-application of mind which can vitiate the findings of the learned tribunal, and hence the order. Section 18 violation, 29, all these points have not been dealt with, not been touched upon by the learned court. Now the propositions, my lord, which we have tried to address. Where the first proposition is 12.1 being a mandatory provision. We have referred to, my lord, Ram Kumar. I'll, my lord, place reference to only one decision, not out of these three, only one, my lord. Ram Kumar and another versus Shriram Transport Finance. It's reported in 2022 SEC Online Delhi 4268. The paragraphs we have referred to, the copies have the pagination here. But I'm not sure whether it has the paragraph numbers indicated as 19 and 22.
Paragraph?
The paragraphs 19 and 22, may I indicate the page number? It's below page numbers 7. It's page 11, minute. Page 11 of the compilation. 19 and 22 is what we are referring to.
Yes.
Terms of the explanation 1 to 12.1. Grounds in the 5th schedule. The learned sole arbitrator was required to be guided by the grounds. Entry 22, 5th schedule. Specifically provides circumstances where an arbitrator has in the past 3 years. So, I'm not reading out, it's 19 and 22 which I'm referring to. That he should disclose and he has failed to disclose. And 26 and 28, no, 26, the judgments are referred to TRF Perkins. And 28, it says, my lord, person who is ineligible to act cannot, my lord, appoint or proceed. And here, my lord, the point was decided in 30 and 31. 30, my lord, the point was that the learned commercial court there in that matter had said that this point was never taken, so this cannot be taken at this stage. 31, this point was negated, saying the view of the approach of the learned commercial court is flawed. Unilateral appointment tantamount to unilateral appointment, which is impermissible in law. The rest of the two judgments I'm not referring to, my lord. The next proposition, 12.5, which we argued extensively, my lord. One more judgment which we have referred to here is Haryana Space Center. This is, my lord, from page 49 onwards. The paragraphs referred to here, my lord, kindly make a note. I'm sorry, I should have indicated in your lordship's copy. Starts from page 49. And paragraphs 17 and 18, which we have referred to here, these are at pages 52 and 53, my lord, of the compilation. This is on the point of constitution, but here it was post the amendment. And TRF, my lord, I'm not reading, I'll not trouble your lordships, I'll only indicate the page numbers. TRF, paragraph 12, it starts from, my lord, page 54 onwards of the compilation. And BSNL, my lord, starts from page 83 onwards. I'll indicate paragraph 12, that is, my lord, TRF. We are referring to paragraph 12. That's at page 65. Your lordships would be pleased, my lord, to take this note. It's at page 65, paragraph 12. And BSNL, my lord, paragraph 15. That's at page 96 of the compilation. The next point which we take, my lord, is paragraph section 29A is a mandatory provision. And my lord, for this we refer to Tata Sons. The 29A is mandatory. And we've referred to paragraph 25, which is at page 124 of the compilation. Starts from page 115. It's at page 124. The next judgment that we are not referring to, power grid, we are not placing reliance on. Then, my lord, violation of section 18. This is very important, my lord, because this is an unamended provision. It was there, my lord, in the Act. Violation of section 18 of the Arbitration Conciliation Act is ground enough for setting aside an arbitral award. We are referring to Sangyong, paragraphs 49 and 51. These are, my lord, at pages 186 and 187 of the compilation. We are also referring to net worth, my lord, that's from it's paragraph 6. That's from page 211 onwards. A Delhi High Court in Wazir Chand, Karan Chand versus Union of India. And in fact, Lord, perhaps one judgment will suffice here. Sangyong says it, my lord. But Wazir Chand is at page 218. Paragraph 15 is at page 218, my lord. And Ruchi Agarwal, paragraph 43, it's a Delhi High Court decision. Paragraph 43 is at page 237. May I only request your lordship to consider one decision, Sangyong. The rest of it, my lord, I will not trouble your lordships with in details. I've indicated the paragraph numbers we are referring to. So Sangyong, my lord, kindly take up page 186 once. I'll quickly indicate those two paragraphs. There is also a sheet anchor of our submission, my lord, because section 18 remains unamended. My lord, kindly see page 186, paragraph 49. Under section 34(2)(a)(3), one of the grounds of challenge of an arbitral award is the party is unable to present its case. In order to understand the import of 34(2)(a)(3), section 18 of the 1996 Act should also be seen. Section 18 is quoted, 24-26 is quoted over the page, my lord, 50 and 51. Model law is referred to in section in paragraph 50, my lord. And 51, sections 18, 24, 3, 26 are important provisions. Under section 18, each party is given a full opportunity to present its case. Under 24, 3, all statements, documents, and other information, paragraph 51, my lord, and other information supplied by one party to the arbitral tribunal shall be communicated to the other party. And any expert report or document on which the arbitral tribunal relies in making its decision shall be communicated to the parties. And section 26 thereafter, my lord, referred to. And paragraph 52, under the rubric of a party being otherwise unable to present its case, the standard textbooks on the subject have stated that there are materials taken behind the back of the parties by the tribunal on which the parties have had no opportunity to comment. The ground under 34(2)(a)(3) would be made out. That's my case, my lord. Because the learned judge, Commercial Court at Alipur, has not made that error where it is recorded that principles of natural justice have been followed. That's not been followed. I've shown that. The next point is unilateral appointment is bad in law, page 6 of the skeleton notes, my lord. That's the next proposition. We are referring to only one decision here, my lord. Dharma Pratishtanam versus Modak Construction, 2005, my lord. Paragraphs 12 and 20. These are, my lord, at pages 254 and 252. 252 and 254, my lord. 12 and 20. I am not referring to Shrey Equipments. only on, my lord, one judgment. But if an arbitral award is not based on any evidence, the same amounts to legal misconduct. This is very important, my lord, because the calculation in the counterclaim has been taken without any proof. To that effect, my lord, we are referring to 2009-12 SSC 1, State of Rajasthan versus Ferro Concrete Construction Private Limited, paragraphs 53 and 54. It's at page 284, my lord, of the compilation. But you will kindly take up that page. It's indicated in those two paragraphs that without any evidence, if this is taken, then it is wrong in law. These are my very respectful submissions, my lord. Very grateful for the patient hearing, my lord. I'm very grateful.
My lord, I can come back on a day, because if lordship is with me, then I have to deal with these
So we
judgments.
can't tell you with whom we are.
Exactly, that's what I'm saying. If my lordship is against me, then I don't have the trouble of dealing with these judgments.
If we are against you.
Yes, because then, my lord, unilateral appointment will prevail. And my lord, I don't have to deal with these judgments at all.
That we can't tell you. So you better.
Exactly. I'll come, my lord, and deal with all these judgments also.
When?
Day after tomorrow. Tomorrow, if your lordship takes, tomorrow, day after tomorrow.
It is the appellate side though. কালকে না পরশু Mr. Bagh, learned counsel representing the appellant, concludes his submission in reply. Paragraph. Since Mr. Bagh has cited certain decisions in course of his reply, which Mr. Banerjee, learned counsel for the respondent, would like to deal with, list this matter once again on Porshudine date the other.
Grateful. Deeply grateful.
It is the main troublemaker.
Sorry.
Item 4 to 8.
Lord, Mr. Bachawat was to appear in this matter, my lord. He was here in the first half. Lord, this item number 4, my lord. Mr. Bachawat is leading, my lord. He's left court, my lord, at 155, my lord.
Tell the whole thing. Not for personal.
Put us in embarrassment. What did we record in
for
the
personal reasons.
No, professional, my lord. He's left court, my lord.
Last time it was for his personal ground. Today it was.
You are for?
The other appellant, but Mr. Bachawat was to start. I am the aggrieved appellant. I am the only appellant who is not willing to send the matter back. They all want. They wanted. They are appellants, but they're asking if the matter be sent back.
You are also an appellant.
I am the petitioner in the section 9. I didn't get the order which I wanted to get, which I was praying.
Hear him then. Why can't we hear Mr. Mitro?
My lord, probably, my lord, for the simple reason.
For strategic reasons, they want to start.
Lord,
That's how last 2 years I've been.
When the appeal was taken up before, we had only started.
They filed once.
My lord, my appeal,
They filed
my
1
lord,
day earlier.
I am a non-party to the arbitration
I'm
agreement.
not asking for any order against you. I made
Set
it.
aside the order against me on, my lord, on concession.
I'm not asking for
No, I am
order.
a
I'm
non-par-
asking for an order against not you, against somebody else.
My lord,
So
in the
now
section
will
9,
let
my lord,
me-
I have been made
Now
a
will let
party.
me address.
My lord, I am a non-party to the arbitration agreement. My lord, I raised that objection before the learned trial court, my lord, citing maintainability, my lord.
He can be
That
made a
is-
party. But then I'm not asking for any relief against him.
He's senior just, I mean. So, my lord, that's the reason, my lord, I was beseeching, my lord, if Mr. Bachawat could be heard first, rest, my lord.
Well, I am not
I am
asking
also
for order
taking-
against him. He wants for for strategic reasons you want to.
Big shot again. In respect of my client, I am the company, the golden goose everyone is fighting.
Yes, I'm asking for order against him. I'm asking for order. He's right, absolutely. I'm asking for order against him. He's a party to the
I am a
agreement.
shareholder of the company, not a party to the shareholders agreement, my lord, which is no longer in existence.
Everybody is aggrieved. By consent, send it back.
Let's set aside
That's
the order.
exactly they want.
Let
I
he
don't
also
want
wants that.
the order. What I'm asking for an
agree, but I don't
injunction.
understand.
Let he's preferred an appeal.
I'm asking for an injunction on negative covenant.
Let
If no order was passed in your favor, if you were the petitioner in section 9, if no order was passed, then how are they aggrieved? How have they come up?
That's the question. That is the big question. Now you ask them, they are all happy to be sent back. They're all happy to be remanded back.
Let us see the order. It's
Can see the order.
intriguing.
compilation, my lord.
Quite intriguing.
But if you kindly take, my lord, takes the compilation, my lord. That's the paper book filed in the form of a compilation.
The first
There's a shareholders agreement. Where one of the order maintains status with regard to a shareholders agreement, which was
paragraph 13 is what the
origin. And after that, a lot of things have changed. Our contention, was the shareholders agreement has already perished. So there's no question of trying to now rely on that. New shareholders have come in, old shareholders are gone.
I am a
Which is the company?
Sorry, Malad?
Which is the company?
This is called Fabwas.
That hotel?
Yes.
JW Marriott.
Yes, lordship is involved. Lordship judgment.
That was a single bench judgment of mine.
Affirmed up to it is pending in Supreme Court, affirmed by division bench, I think.
By division bench.
But there's no stay, and that's been the
Mr. Chidambaram had appeared, and Mr. Jayantu Mitra as Advocate General. You had appeared with Mr. Chidambaram.
No, I was not.
I think it was relating to the property.
Property, I think something.
Corporation tax.
Corporation tax.
Corporation valuation, whether it's
Lessee, owner.
KMD, whether it be private.
KMC के साथ में जो झगड़ा था.
Annual valuation.
क्यों ऑर्डरটাই খুঁজে পাওয়া যাচ্ছে না?
Well, any memo of appeal will show. Any memo of appeal will show.
The compilation.
There are 5 appeals. Any of all of them.
But in my appeal, my lord, the compilation was directed to be filed, my lord. Page 1.
What are the?
This is on a section 9, Malad, which was passed, Malad, where Malad they wanted to injunct Malad and a UOGM Malad to be held Malad of Fabwas. With regard to Malad issue raising capital.
More than 2 years old.
Yes.
Well, but that's the
and
that's how Malad
order of Malad of some time.
But we filed within a week. Within 3 or 4 days. That is something. Let's all go back. That is the other appellant's grievance. You said let's all go.
Kindly look at Malad.
You will now kindly see paragraph 13 of this.
8 and 9.
This is 6-page order. Let us read it once.
Yes. We have to start. We'll have to start.
Kindly read paragraph 13. That's where the
Paragraph?
1-3. That is where the learned judge finds.
8 onwards, my lord.
Up to 12 is the submission.
8 is our objection.
Then I can also read, my lord. Is
8
reading.
onwards.
13 is the conclusion.
Ten is my point of maintainability. When I can't file affidavit on day 1, therefore injunction.
So relieved by the order. Really fathom what's happening.
May I?
Now, that is why Mr. Bachawat,
Mr. Bachawat, Milord is a non-party to this. There's a 2011 agreement.
Mr. Mitru, you have taken up the matter. Now that we have taken up the matter, don't worry, we'll take it up day after tomorrow again. But day after tomorrow, ask Mr. Please request Mr. Bachawat to be here.
I don't. 14th of May.
Then you fix it accordingly. No?
Day after tomorrow, you're not there.
14 Malad,
Long change of jurisdiction.
no, 14th is also a good day not to be in court.
Next Tuesday. Next Tuesday.
We'll be there.
Lekho. We have taken we took up these 5 appeals for hearing together, as they are all directed against the order dated.
The 5th appeal is separate, my lord. So the 5th appeal in the list, my lord,
That's a different order. Then which ones?
25th July 4, 5, 6, 7.
No.
Not 4 to 7.
5, 6, 7. Achha, 4, 5, 6, 7 tax shonge karo. As they are all directed against an order dated July 25, 2023, passed by the learned judge, commercial court at Alipur, in Miss Case, arbitration 28/2023, filed by the appellant in FMAT 345 of 2023, correct?
Mine is, I think,
mine
28.
28 is mine.
FMAT is 31 of 2023.
My lord, yes.
Stop.
Item 7.
Paragraph. We have heard learned counsel for the parties for some time. Stop. On the ground of Mr. Bachawat, learned senior counsel representing the appellant in
28, my lord.
FMAT 28.
FMAT bracket Arbor Ward dekhin heuristic 28 of 2023, let these matters stand adjourned and be listed again on Tuesday, date diye dao, Shamne Tuesday, retaining at the same position, আর ওই অন্য ম্যাটারটায় just adjourn করে রেখে দাও।
FMAT 31 malad is mine. So that, কোনটা?
31, yeah. 5, 4, 5, 6, 7 will be together.
32 will also appear on 19th. Item 9.
Yes, correct. But ওটাকে ডিট্যাগ করো, ওটা অন্য অর্ডার থেকে অ্যাপিল। 8 নম্বরটাকে ডিট্যাগ করো, পরপর থাকবে বা ডিট্যাগ করে দাও।
They can't afford to delay, so in case I'm a little late, Mr. Mukherjee will start.
We are going to start now.
Have you given that judgment?
I've already given 2 judgments.
এই ওই ম্যাটারটা যেটা জয়েন্ট তুমি
I am for the appellant, my lord. Mr. Ghosh on the other day had raised an objection that there was a claim and a counter claim, and I have filed only one appeal. So he was to cite judgments on the point that there had to be 2 appeals, and this appeal is now barred by the principles of res judicata.
Yes, maintainability. If you are taking that point, it's a preliminary point.
The plaintiff appellant filed a suit for recovery of money. I appeared, filed my written statement with counterclaim.
Vishnu Narayan Kunar.
And all the respondents, defendant respondents.
How many?
5. 4. 4. The suit was contested, suit was heard, and by the order impugned, the learned trial court allowed the counterclaim and dismissed the suit. Now, if you also kindly see the judgment first, the order in portion. In paper book, page 170. A paper book has been filed.
Yeah, the operative portion only. Yes, suit is hereby dismissed on contest.
Contest against the defendant, but without any
Counterclaim decreed on contest.
against the plaintiff, but without any order as to cost.
10,58,000, they have now secured it.
Yes, my
All very well. Yes, then.
Let us see the decree, the next page.
কোথা থেকে দেখছি পেপার বুক তো পেজ কত বলতো
169.
What? 169.
169 the decree.
Yes.
But I showed the decree.
Yes.
Now, kindly see the. Now, kindly come to the memo of appeal. Let us see how the appeal has been valued. Now, the memo of appeal is at page 173. Memo of appeal is valued at rupees 66,23,780.
How much was his claim?
66,23,780. That was his claim, and that was the value of the memorandum. But on the memorandum, it's appeared this is not a common appeal challenging the suit as well as the counterclaim. If it is counterclaim and suit has been challenged, simple.
Then it would have been 76 lakhs and odd.
76 lakhs and odd. Then on the time of filing of the appeal, they ought to have filed the court fees relating to their claim only, not against the counterclaim.
Tell me the position. For filing a suit, isn't there a ceiling for court fee 50,000 in West Bengal? There is a similarly for appeals. There is also a ceiling. No.
Case of appeal subject to correction, there is no such ceiling.
No ceiling.
At the time of filing of the suit there is a ceiling.
But appeal ad valorem, however.
Subject to correction. So they are required to demonstrate what is the value of the appeal. If it is the suit and the counterclaim together, they are required to value the suit valued as rupees such and such, counterclaim is valued as rupees such and such. But in the memorandum of appeal, it says only the valuation of the suit. There is no mentioning of the counterclaim. What I told you, Lordship, about the valuation of the appeal. So from the appeal itself, memorandum appeal itself, it shows there is no whisper of challenge to the counterclaim as it appearing from the memorandum appeal. No matter it is a well-known law, and it is also a code of civil procedure that Order 8, Rule 6A dealt with the counterclaim. If I Lordship read for your Lordship what is Order 8, Rule 6A, then we will go further.
No, they have challenged the counterclaim, Mr. So look at ground number 12.
There may be some ground, but doesn't mean it is challenged to the counterclaim. There may be some ground.
There may be deficit court fees.
Consider if a suit and counterclaim disposed of by a common judgment, there should be a 2 decree. Because their suit is dismissed or allowed, whatever, there should be 1 decree. And for the counterclaim, there should be another decree. Even if we sake of argument, if a sake of argument, we say that no, there is only 1 decree. But that doesn't mean the judgment which was passed, a single judgment passed considering both the matter, maybe there is a decree, 1 decree, but since the judgment has been passed in common,
So, what I'll say, finality of the judgment in one suit is res judicata to finality of the judgment in another suit, which was hard together. Maybe the decree may be one or two, whatever. In this case, though the decree is required to be passed in two, because suit was dismissed, my counterclaim allowed. So there should be two decrees. Even if there is one decree,
Common judgment, if there is common
there is a
judgment,
common
two
judgment.
appeals. Why?
Here should be the finality of the finding in connected suit due to non-filing of appeal
Correct.
preclude the court from proceeding with the appeal in other suit. But if I read the provision of counterclaim in as per the CPC, may I read for your lordship? Order 8 Rule 6A, a defendant in a suit may, in addition to his right of pleading or a set off under Rule 6, set off by way of counterclaim against the claim of the plaintiff, any right or claim in respect of cause of action occurring to the defendant against the plaintiff either before or after filing of the suit, but before defendant has delivered his defense or before the time limited for delivering his defense has expired. Whether such counterclaim is in the nature of claim for damages or not, provided that such counterclaim shall not exceed the pecuniary limits of the jurisdiction of the court. Such counterclaim shall have the same effect as a cross suit, so as to enable the court to pronounce a final judgment in the same suit, both the original claim and on the counterclaim. The plaintiff shall be at liberty to file a written statement in answer to the counterclaim of the defendant, with such period as may be fixed by the court. The counterclaim shall be treated as a plaint and governed by the rules applicable to the plaint. So that we can easily say the counterclaim is a cross suit. If a suit and a cross suit is decided by a common judgment, though there may not be a two decree or there may be a one decree, but judgment in one suit is res judicata to another suit. But not only that, another clearing issue will be that when one decree is challenged in a single appeal, that not only the res judicata, their question will arise the law of estoppel and accountances. There will be estoppel and accountances. But I'll demonstrate from the some judgments of this Honorable Supreme Court, which was time past. I'm already handed over to my learned friend also.
So therefore, what happens?
Specifically from it.
No, but if we go back to the judgment,
Mr. Gupta, are you not challenging the counterclaim?
I am.
How?
I have taken grounds in my memo of appeal where
Counterclaim is a separate decree.
subject to what falls from your lordship, my lord, there is a judgment which says that if there is one suit, common trial, common evidence, one decree, be it claim and counterclaim, there cannot be separate decrees. There has to be one decree and can be challenged in a single appeal.
Even if there is one decree, two appeals. Bring your decision then.
Very well, my lord. I'll
Bring
get
your
that.
decision. Let him satisfy. Yeah. By the judgment and decree impugned in this appeal, the appellants / plaintiffs claim in the suit was rejected and the counterclaim of the respondents / defendants was allowed. Paragraph. Learned advocate for the respondents raises a preliminary objection to the maintainability of this appeal. Stop. He says that a common appeal against the decree dismissing the suit and allowing the counterclaim would not lie. Stop. The appellant should have filed two appeals. Stop. Paragraph. Learned counsel for the respondent also points out that the appellant has valued the appeal at rupees
66 lakhs, my lord.
66 lakh and odd.
23,708.
6623
718.
718, which was the amount of his claim in the suit. Stop. Therefore, in any event, the appeal is undervalued. Stop. Paragraph. Mr. Gupta, learned counsel for the appellant, seeks a little time to respond to the aforesaid points. Paragraph lists the matter once again day after tomorrow. You also bring your decisions, whatever you have.
I also given him the.
He has given me the citation.
Number 1.
But I'm for the appellate. Mr. Bagh, my lord, addressing regarding the territorial jurisdiction of the court, city civil court, my lord.
On your other side.
My lord.
So Bagh is appearing in this manner. It's ready. Take a short passage.
Number 2. Wait, please, your lordship. It's my appeal. I'll be very precise. There's a short point involved. The respondents Lordship, I will not trouble with any of the facts. Your Lordship can take it from the face value. It's a peculiar point. The respondents have initiated and obtained an ex parte interim order on an alleged arbitration agreement in October 2024, against which we had originally filed a Section 37 appeal, stating that there is no arbitration agreement and the subject matter falls within the domain of a commercial court, and the learned single judge could not have passed that order. In the interim, ex parte proceedings of arbitration were done. We moved this court under Section 14. It was set aside. Thereafter, the respondents have applied before this court under Section 11 on the commercial side of the court, which was dismissed with the liberty to file fresh because there were technical defects of 21 notices. By this time, the appeal which we have filed, and we had informed the learned trial court that, look, we had filed a petition. This is a commercial matter. It could not have been entertained by this court. The interim orders could not have been passed. So the division bench of this court, considering a view, passed an order directing the learned trial judge to decide this issue because it's a subject matter. My learned friends there go and contest that this is not a commercial dispute, and here they file for appointment of arbitration proceeding in a commercial side which is pending. Now, in spite of communicating the order of this honorable court, the impugned order which has been passed, which is at page 23 and 24, the first 23 is an ex parte order and 24 is the order passed. I'll just first take your lordship to the order passed by this honorable court, page 193.
Before my learned friend proceeds with the merits of the matter, my lord, I just indicate, my lord, the section 11 application is pending before the other bench, my lord, and it's my lord, fixed for hearing on 20th of this month. So if
that
a complete, my lord, is a contested application, your lordship, if the matter could be deferred, my lord, till 20th, your lordship, then
my only request, ex parte ad interim orders have been obtained, making false statement before the trial court, despite the order of the honorable court that this is a subject matter commercial divisions, petitions are being filed. There is no arbitration agreement, but the interim order cannot continue. Kindly comes to page 193 once.
Interim order was extended till 31st July.
Yes.
Then what happened after?
Thereafter, we informed that there is an appeal filed. We had even mentioned, again, the matter has been posted to November.
And interim order has been extended.
Yes. Kindly comes to page 193 of this order passed by this honorable court. Well, we are the officers of the court. I can understand my learned friend clients can get interim orders. But at one hand, he is moving to the commercial division, and the other hand, he is on oath saying it is not a commercial dispute. This court has to pass an interim order. This can't be done.
No, so by the impugned order, the court has held that this is not a commercial dispute.
Your Lordship, by the impugned order, the court has held this is not a commercial dispute. This matter has been admitted by the learned district judge, transferred to me. The authority cannot be challenged. The dispute is between landlord and tenant. It's not a commercial dispute. And when on their own affidavits, pleadings, my learned friend have moved the commercial side of this honorable court and not disclosed the facts. And over there, they are submitting this is not a commercial dispute. Over here, orders are being sought from the commercial court.
My lord, if I may humbly interject, your lordship.
Well, may I just rephrase it, your lordship? I'll just. My learned friend filed a Section 9 petition before the learned civil court and sought an ex parte interim order, against which ex parte interim order we come up with Section 37 appeal stating, first, there is no arbitration agreement, and second, the court could not have passed an order because it is a commercial matter ought to be decided by the commercial court. Pendency of the appeal, my learned friend proceeds with unilateral arbitration proceedings, which we come before the commercial side of this court, get it set aside.
Unilateral arbitration proceedings?
Yes. They have appointed the arbitrator suo motu started the proceedings. We, in the interim, in that appeal, we mentioned there is a stay of the arbitration. Thereafter, under Section 14, which we filed, the mandate was terminated. The first Section 11 was dismissed. That notice was not improper. Thereafter, they file a second Section 11 petition, which is pending before Justice Shampa Sarkar. Pleadings are complete. Our contention, there is no arbitration agreement between the parties. Having said that, this appeal which we filed came up for consideration before the division bench presided by Justice Bhattacharya, where we indicated that in the trial court, we file an application stating the subject matter does not fall within that domain. It is a commercial matter. The learned Barasat court could not have entertained the matter and could not have extended the interim order. Having said that, Justice Bhattacharya passed an order
Well, section 14 was also filed before the commercial dispute.
What was the agreement between the parties? The agreement relating to the property, real property?
There was no agreement with the appellant is concerned. It was against the erstwhile appellant. I am a successful resolution applicant. I had come into the CIRP. It was a lease agreement for a commercial. What is the agreement they are relying upon? It's a lease for use installing mobile towers. Where will they take rent from me? From my corporate data.
So it should be covered by 21C7.
Exactly my point. Having said that, I go to the court. I say it could not have been entertained. They in the section 9 court say it is not a commercial dispute. And the High Court, they filed petition on the commercial side saying it's a commercial dispute. Now today he's saying the section 11 is pending. The interim order is continuing for me. Kindly comes to page 193 once, Your Lordship. Your Lordship have a clarity. I could have understand the fathom, but we are also officers of the court. We have to be honest to the brief. Kindly sees 194 read with page 24 of the impugned order. That will make the subject clear. Volume 2, 194. 193.
But I'll just indicate one thing, Your Lordship, that 2 orders have been challenged by way of this appeal. Under section 37, my lord, they have challenged the interim order that was passed under section 9 and subsequently in 151 application under CPC. Now, whether an appeal can arise out of section 151 under CPC or not, my lord, that has to be decided as well. My lord,
it's a final order extending the interim order.
Very well, my lord. Since it has been filed under 151 of the CPC, my lord, whether that
this court directed the trial court to decide the issue of commercial dispute.
Yes.
No.
Yes. Kindly comes to page 193 once.
Section 9 has to be decided by
the... I am answering the query of the court. May I place the order?
This you had come up against what order?
Your Lordship, the order, the first order which was under challenge and the last order of 31st July, 9 July, by which the interim order, this application was rejected and the interim order was extended again. The original ex parte interim order, which was subsequently extended by order of 9 July. Page 24, 23 and 24 of my stay petition. 23 is the first order which I had preferred an appeal. And 24 of 2nd July 2025.
This appeal can't be against those 2 orders, sir. This appeal, this order is dated 24th June. How can this be an appeal against 2nd July order?
There is 2 appeals. One is first appeal of 1st
confusing us, sir.
Your Lordship, I am challenging 2 impugned orders. One is 1st October 2024.
We are asking this Justice Bhattacharya's...
I am not against that order.
This is against which order? This section 37.
Justice Bhattacharya's order is also against the order which is at page 23.
Page 23, right.
Since Justice Bhattacharya's order did not decide on the merits, so I am again challenging that order of page 23. And subsequently page 24.
এইটা এই অর্ডার 2nd জুলাই পাস করে বলছে আমি পারি না আমার কাছে ডিস্ট্রিক্ট জাজ পাঠিয়ে দিয়েছে আর এটা একটা খালি ল্যান্ডলর্ড টেনেন্টের ভিতর অ্যাকাউন্টস নিয়ে ম্যাটার এটা কমার্শিয়াল বলে interim order extend করে দিয়েছে। This is obviously a commercial dispute on the face of it. Relating to property used exclusively in trade and commerce. বলে পাঠিয়ে দিয়েছে করে দিয়ে।
I'll just indicate 2 points.
What?
Not whether the question of limitation will arise or not, my lord, that has to be looked at.
That will decide.
And the second question is, your lordship, against 151 that has come up, my lord, as way of challenge under section 37. So, my lord, whether 151 applications appeal can be entertained by
Justice Bhattacharya on an earlier appeal under 37 had directed the trial court to decide the issue of maintainability in a non-commercial court, in a civil court. The learned judge, just by writing one line that it has been sent to me by the district judge, we are setting it aside. We are saying it's a commercial dispute. Everything is left open for the arbitrator to decide. We are holding nothing against you, nothing in favor of them, nothing against them also.
The interim order is vacated, your lordship. But that would prejudice me, your lordship, because my property is there that they have been utilizing for commercial purpose.
What can be done? If you have, yes, you could have approached the commercial court. It's your doing. You have approached the wrong forum. What can we do? Immediately, we'll grant you liberty. Immediately approach the commercial division. Who's stopping you? With the same application, you can approach.
But in the
Sir, we'll transfer it to the commercial division. You should have no objection there. And we will set a time limit for deciding the issue of interim order.
Transfer it without the interim order.
Without?
The interim
that is
order.
going to
Your Lordship, the difficulty understand. An ex parte order obtained. And then I am challenging the page 23 order. An ex parte ad interim order, which is in the nature of a final award. Kindly sees page 23, Your Lordship. That is the order in the impugned. The order has been passed that I have to continue to make payment of the property rent.
We cannot continue the order, sir. To save time, we can transfer it, but we cannot for the simple reason the order is a void order. Since we are holding that this is a commercial dispute and therefore it should be adjudicated by the commercial court, the order is without jurisdiction. How can we extend an order without jurisdiction? We follow what we are saying. So we'll transfer it and we'll say that the issue should be considered afresh in accordance with law within a specified time period.
Yes.
More than that, we can't do anything. Issue. This appeal is directed against an order dated July 2, 2025, passed by the learned order by
8th additional court.
8th additional district judge at Barashat in Miss Arbitration 46 of 2024. Paragraph. It appears that the respondent herein, respondents, respondents, no.
Respondent,
Respondent number 1.
Yes.
Herein approached the learned trial court with an application under Section 9 of the Arbitration and Conciliation Act, praying for certain restraint orders against the appellant herein, including, where's that first order?
Page 23.
Including an order to restrain the appellant herein from removing the machineries installed at the leasehold property without paying the dues of the respondent number 1 herein. Stop. This was done on the basis of an agreement relating to a lease agreement relating to the concerned property. Stop. Apparently, mobile tower.
Yes.
A mobile tower has been set up on the property. Stop. The respondent here, number 1 herein, being the owner of the property, claims that there are dues to her from the appellant herein. Stop. Hence, the respondent number 1 herein filed the Section 9 application to protect her interest. Paragraph. On October 1, 2024, the learned trial court restrained the appellant herein from removing its machineries installed on the leasehold property without paying the dues of the petitioner before the trial court. Stop. Paragraph. Upon receiving notice, the appellant herein approached the learned trial court contending that the dispute between the parties was a commercial dispute within the meaning of Section 2 bracket 1 bracket choto c bracket choto VII of the Commercial Courts Act, 2015. Stop. The appellant herein also challenged the order dated October 1, October 1, 2024. Where's Justice Bhattacharya?
Page 193, Your Honor.
193.
Volume 2.
By filing FMAT 394 of 2024. Stop. By a judgment and order dated June 24, 2025, a learned judge of this court disposed of that appeal a coordinate bench of this court disposed of that appeal. Stop. The operative portion of the said order reads as follows. Page 195 থেকে set out করে দাও। এই paragraph 5 আর 6 টা। Paragraph. It appears that subsequently the Section 9 application appeared before the learned trial court on July 9. Is that correct?
2nd July.
On July 2.
July 2.
July 2, yes, 2025. Stop. We are told that the learned judge has adjourned the matter till November 28, 11.
11th November.
November 11, 2025, and has extended the interim order till the next date. Stop. Being aggrieved, the respondent number 1 in the Section 9 application has come up by way of this appeal. Paragraph. The appellant argues that on the face of it, the dispute between the parties is commercial in nature and is squarely comes within the purview of Section 2 bracket A1, bracket A choto c, bracket A VII of the 2015 Act. Stop. Therefore, comma, the Section 9 proceedings are not maintainable before the learned civil judge who lacks jurisdiction to entertain the application. Stop. Paragraph. Should we record anything on your behalf?
We are only challenging regarding the maintainability of the appeal.
Learned advocate for the respondent number 1 says that this appeal is not maintainable. Stop. The appellant herein, the respondent number 1 herein not only invoked Section 9 of the Arbitration of the 1996 Act, but also Section 151 of the Code of Civil Procedure. Stop. Therefore, comma, this appeal does not lie. Paragraph. We are not impressed with the argument on the point of maintainability of the appeal. Stop. Paragraph. Section 2, bracket 1, bracket C, bracket VII defines a commercial dispute as a dispute arising out of, comma, inter alia, comma, quote karo, agreements relating to immovable property used exclusively in trade or commerce. Stop, unquote. Bolbi kichu. So, paragraph. On the face of it, comma, the agreement between the parties here too relates to immovable property used for the purpose of commerce or business. Stop. As we noted above, comma, the immovable property in question was leased out for the purpose of installation of a mobile tower by the appellant. You are a mobile company.
Leased out to the...
Okay, very well. For the purpose of installation of a mobile tower. Stop. Hence, comma, by no stretch of imagination it can be said that the dispute is not a commercial dispute. Stop. In that view of the matter, comma, a paragraph karo. In that view of the matter, comma, the learned civil judge would not have jurisdiction to entertain the Section 9 application. Stop. The application should be heard by the relevant commercial court. Which is that?
Commercial court, Rajarhat.
By the relevant court, by the commercial court at Rajarhat. Stop. Paragraph. We therefore direct that, can we direct transfer?
Yes.
Beautiful. We therefore, comma, in exercise of power under Section 24 of the Code of Civil Procedure, comma, direct that miss case number 45,
46 of 20.
46, 46 of 2024, bracketed ARB, comma, pending before the learned
8th Additional District Judge Barasat.
8th Additional District Judge, comma, Barashat, comma, be forthwith transferred to the commercial court at Rajarhat. Stop. The parties shall take all necessary steps for to give effect to this order. Stop. Paragraph. Since the interim order was passed by a court lacking jurisdiction, comma, we cannot sustain it or continue it. Stop. However, comma, the learned commercial court shall consider the issue of passing interim orders in favor of the respondent number 1 herein, comma, if so requested by the respondent number 1, comma, as expeditiously as possible, and within and will take a decision on that score within 3 weeks from the date of transfer of the Section 9 proceedings from the Court of the Learned Additional District Judge, comma, Barashat, to the Commercial Court at Rajarhat. Stop. We make it clear that we have not entered into the merits of the case. Stop. All points are left open for the learned commercial court. Now, all points in the Section 9 application are left open for the learned commercial court at Rajarhat to decide upon hearing both the parties. Stop. Paragraph. You are saying limitation or something?
What I was placing is, Your Lordship, the order that was passed was in the year 2024, and subsequently, if, my Lord, subject to correction, Your Lordship, the Limitation Act Section 116 comes into play, my Lord. This is barred by limitation, my Lord.
What is barred by limitation?
Barred by
Well,
limitation.
that we can always condone. These are very technical points. Don't worry about those. Now, paragraph. The appeal and the connected application accordingly stand disposed of. Stop. Learned Registrar General of this court is requested to immediately communicate this order to the learned district judge at Barashat and also to the learned 8th additional district judge at Barashat for doing the needful.
For the interest of justice, Your Lordship, only an interim measure, my Lord, relief may be given to me, my Lord, for a stipulated period of a very short, my Lord, if that can be given, my Lord. This is what I'm humbly praying.
I'll oppose
because
it.
the transfer will take for some time, it will take, Your Lordship. That's why, my Lord.
Lordship, ex parte ad interim order, they have been taken. It's a final order. There is no agreement.
Without jurisdiction. Days. And very expedite with the from removing. If you remove, it will be only after inventorizing in the presence of his representative, and till the commercial court decides the section 9, you will not dispose of this. You will not dispose of these equipment.
These are my equipments. I will not dispose of.
That's right.
Very
Use it. We are not stopping you.
Yes, grateful.
Communicate করার আগে. Considering that the respondent number 1 herein was enjoying an interim order since October 1, 2024, we clarify that in the event the appellant herein removes its equipment, machinery, whatever, from the concerned plot of land, the same shall be done only after inventorization of the same in the presence of the representative of the respondent number 1 herein. Stop further, such equipment machinery shall not be disposed of by the appellant herein till a final decision is taken by the learned commercial court in the application under section 9 of the 1996 Act. So both of you can smile and go out happy.
My lord, I am appearing for the petitioner. My lord, kindly allow me to appear virtually.
It is very difficult, ma'am. Why are you not appearing physically?
No, my lord, I was in the court, my lord, but I have came to the Central Administrative Tribunal, and due to some difficulty, my lord, I could not return to the High Court.
Then you
Kindly
better
consider, my lord.
You better do your case there. We'll adjourn it for the day.
Yeah, let me be taken about Tuesday.
Tuesday. It's a contempt.
Yes, my lord, this is contempt.
Not maintainable, I will come with an evidence on Tuesday.
Very well.
It is not at all maintainable.
Learned advocate for the এটার পরে আগের ম্যাটারটা একটু চেঞ্জ করব মনে করে দিও learned advocate for the petitioner seeks leave to appear virtually. Stop. The connectivity is not so good. Stop. Paragraph on the request of learned advocate for the alleged contemnor. One contemnor, no, alleged. You appear for both.
One has been transferred.
Oh, alleged contemnor karo. Let this matter stand adjourned and be taken up again next Tuesday date thou. Stop. On that date, the alleged contemnor is directed to file an affidavit bringing on record what steps he has taken to comply with the
Maintainability. No order has been passed by this honorable court. So I will come with maintainability passed.
No order has been passed.
That I will show.
Very well. What steps have been taken by him for complying with the order in question? ওইটাই লেখো ওখানে সিন্স কি বলেছিলাম লাস্টে কমিউনিকেশনের আগে যেটা বললাম সিন্স দি রেসপন্স এন্ট্রি মোডের দেখো না protection. Has been enjoyed, some protection. ঠিক আছে? Please on the next occasion, make it convenient to be present here.
Yes, my lord. My lord, definitely, my lord. I am sorry, my lord. Definitely, my lord.
Okay, thank you.
Grateful, my lord.
For the respondent, my lord, I'm led by Mr. Siddhartha Banerjee in the matter.
Contempt?
No, my lord. My lord, this is my appeal, my lord.
Oh, assigned matter. Oh, that matter.
Yes, Mr.
When will you
Banerjee.
complete?
My lord, Mr. Banerjee had to leave the court for some personal difficulties, lordship. So if my lord's May I just make one humble prayer, Lordship?
You have to then conclude, madam.
Shall, my lord, if it's taken up on Thursday,
Day after tomorrow.
day after tomorrow, if Mr. Banerjee is for some reason not present, I will move the matter.
You will
Friday.
conclude the
I will
argument.
conclude, my lord.
That's fair. Because I know Mr. Banerjee has illness issue in the family. I know that for sure. Thursday is all right with you?
Yes, my lord. My lord, can a time be fixed if it's convenient for your lordship at 2 p.m.?
4:45 p.m. That time. It will be called on. It's called
Very
called
good, my lord.
on. কিছু লিখো না, not today করে রেখে দাও।
Grateful.
Five, my lord, I am applying for the appellant, my lord. Mr. Nobokumar Das is my senior in this matter. It is a short password, my lord.
How short?
5 minutes at least.
5 minutes?
He is engaged in code number 42. That's short password.
2008 appeal.
My lord.
The respondents are not contesting possibly.
And he is there, my lord. Code
They are
number 42, my lord, matter is just 5.
Pass over.
My lord.
Second call.
Passover matter, item number 1.
Please, my lords.
Oh. He's your other side.
My lord.
He was trying to displace you. What is it, Mr. Bagh? I don't remember a thing.
Section 9, we had passed in our favor by the Civil Court. But the point taken, they have not challenged the Section 9 order. They filed a petition before the Civil Court for, my lord, it was in the nature of a demurrer, where, my lord, they have challenged that the court could not have entertained the Section 9 petition. The order is subsisting, my lord, in our favor. Point taken there is, my lord, in the withdrawal application, is, my lord, pecuniary jurisdiction was a point, but they have argued territorial jurisdiction. So the point which fell for consideration before your lordship, there are other points taken, but your lordship, my lord, had posed a query that how can the court, without having a territorial jurisdiction, pass this order? Section 9, if the order is without territorial jurisdiction, then the order has to go.
Where's the order?
My lord.
Memo. Memo. February.
Other points which were taken, my lord. The first debate argued, but mainly, my lord, the second page, the last page of the order. The last part of the first paragraph in the last page where, sorry.
You are the petitioner before the
We were the
city court.
irregular. Yeah.
What is the nature of order passed in this case? I like this observation. We both of us like, Mr. Bal.
That part of the observation.
Yes, Mariva. So what is the nature of the order passed here?
We have the ordering portion, not to deal with or
And not to dispose of money.
status quo.
As regards property.
This order they have not challenged. That is not under challenge. What is under challenge is section 9.
Well, it's an order, ad interim order.
Ad interim order is not, where is it? Ad
My lord, I
interim
just handed over copy. My lord. I have not annexed one.
Not annexed.
Lord, I have not annexed. I have read the petition. Without, let me do the issue. Yes, yes.
Where is the suit property?
Like EM bypass.
More
And I'll indicate now. I have an answer.
My lord, before my lord,
Section
Mr. Bagh
9.
start, my lord, only one point. My lord, Mr. Bagh has submitted that I have not taken the point of territorial jurisdiction. My lord, I have taken this.
We have seen that. The judge has referred to.
They're in the order.
Yes.
From the petition, I can show it is not there. They're in the orders. I'm not even pressing that. But my only point is, it's a point of law now. Section 9 will not be guided by territorial jurisdiction. Supreme Court has said that. I'll be relying on that. And my lord, in that it has been explained what is the difference between Section 9 and
In what it has been explained?
it has been explained that if you file a Section 9 petition,
Explained by whom?
to the Supreme Court.
I see.
I have, my lord, 3 different judgments which I'll place reliance on. Where, my lord, it is explained that Section 9 and territorial jurisdiction is not the guidance for Section 9. Section 9 will be guided only by seat. So if the seat is mentioned, then nothing else is to be looked into. It tantamounts to an exclusive jurisdiction. And if seat is not mentioned, then either a part cause of action will be shown, and from a part cause of action, it can be called out the jurisdiction. Here, my lord, there's a judgment in Arif Azim, where, my lord, the Supreme Court has now explained in 2024 that if a seat is not indicated, it's venue. Then, if there's nothing to the contrary, there is no dispute. If a venue is clearly mentioned in a dispute resolution clause, that will be construed as seat and nothing else.
What is the seat of arbitration?
So the seat in an international arbitration, my lord, seat is the governing law. My lord, it's the lex curiae. The lex fori is, my lord, the venue. So, my lord, seat is the agreement between the parties that we will be governed by this law, the substantive law of this country. And, my lord, this court will have supervisory jurisdiction over this entire proceeding.
Let us confine ourselves to our country.
My lord, domestic has followed the same thing. My lord. That's why, my lord, I started with the international arbitration, because really this dispute between seat and venue is, my lord, something which applies that the difference between the two is, my lord, when it comes to 2 different jurisdictions. In India, my lord, the seat and venue will not be really 2 different jurisdictions, because the governing law.
Which doesn't happen. We decide that when arbitration involved, the property is in Calcutta, so all courts will have jurisdiction. The seat is there.
So the governing law will be the same. So it will be the Indian laws. The only thing that the seat would do is, my lord, which court will have exclusive jurisdiction. Venue, my lord, can be chosen by the parties, it can shift. So that is the premise of the, my lord, the judgments, that seat cannot be changed. Once it is decided between the parties, it cannot be changed. The venue can be changed. So today, my lord, if the clause reads.
So in this case, have we agreed on the seat?
We have, my lord, the venue has been agreed to. And, my lord, through Arif Azim, I'll indicate the parameters are getting satisfied, that there is nothing to the contrary, which, my lord, creates a doubt.
What is the venue?
The venue is Calcutta. And that is why, my lord, City Civil Court will have jurisdiction to pass this order.
No, Calcutta courts. Does it mention City Civil Court?
No, my lord. The venue of arbitration shall be Kolkata, India.
Appropriate court in Kolkata.
Appropriate court
The court having jurisdiction.
in Kolkata.
Yes. Eastern Metropolitan Bypass. Go to the appropriate court. Who stops you?
My lord, any court. So, my lord, see, the moment, my lord, the venue states Kolkata, India, it would mean.
Mr. Bagh, show us the cases. You are not serious when you are saying that. Any court.
I'll indicate that.
Any court in
And,
court.
my lord, that is what the interpretation is. My lord, that is why, my lord, I wanted to go back and check again. And I've checked. And now, my lord, with these judgments, perhaps I can, my lord, kindly permit me to, my lord, first indicate the dispute resolution clause, which is 48.
So then start next day. You have 3-4 cases to cite.
I have, my lord, 1, 2, 3, 4 judgments.
So next day, because I have to rise a little early also for administrative
And
reasons.
indicate, my lord, that this is the only.
Why don't you do this to shorten the time period? Give him the citations
We will. I'll
so that he can consider and come back. Heard learned advocates for the parties for some time. আলাদা কথা. Paragraph. এটা কবে হবে আবার? পরশু? Day after tomorrow? Paragraph list this matter once again on পরশু date দিয়ে দাও.
Item 5 was also passed over.
Sure.
Keep your judgment.